Good afternoon, everyone. Today is June 13th, and the time is 1:02. Has the front lobby been cleared? Thank you. We are here today for our school board briefing meeting today. Welcome, everyone. Board member Morgan will not be joining us today. Does the superintendent have any changes to the agenda or any other issues?
No changes, Mr. Fisher.
Okay, on the agenda today, we have 8 items. Per board protocol, each member should strive for 4 minutes for initial comments, 2 for follow-up, for a total of 10 minutes. Right now, let's proceed to item number 1, which will be quarterly reports for school board advisory committees. And I believe up first will be Construction Advisory Committee, CAC. Welcome.
A very short update. We only had 2 meetings this quarter. So I'm Clarissa Parodi. I'm the chairperson of the Construction Advisory Committee. And first, I would like to thank Ms. Debbie Jordan for the liaison with our committee and the team of facilities for all of the updates regarding the new construction, the ongoing construction, the hurricane repairs. We know we ask a lot of questions, so we really appreciate your help. And say that, I would like to talk a little bit about our discussions. The first item, and something that we've been discussing for a while, is the explore the locations to install solar panels on school campuses. We had many presentations from different renewable sources, companies, but at this point we voted to postpone any recommendation to the board. We think that there's incomplete data to justify the investment. We talked to facilities, we talked to these companies, and we think that the benefits are not there yet, but we're going to continue exploring the options before we come here again. As a general discussion, it was brought to our attention the lack of workforce housing in the district, and it's something that we want to explore in the future. Maybe private partnerships, or how we can work with the board as a CAC committee, how can we help with that? That was in April. In May, in the main meeting, the highlight of the meeting was a public comment by Denise Elber from the Alba Inc. Board of Directors. She brought to the committee a concern about the site selection for a new high school in Tuckahee Road, I cannot pronounce that, and Joel Boulevard in Alba, as she feels and her board feels that the population in that area and the lack of utilities don't support a new school. So we directed her to come to the board, but also that triggered a discussion in our committee to how we can be more involved with planning to help with site selections to the background of our committee. And then last but not least, we had a presentation by ADG Architecture regarding the Performing Arts Centers for Veterans Park that will be shared by Veterans Park, Academy for the Arts, and Lemuel Till Middle School. And we like the project. I shouldn't say that, but and that's it. That's what we did this quarter. So I'll be back again in 3 months. Thank you.
Thank you. Next up, Continuous Systematic Improvement Advisory Committee, CSI.
Good afternoon, board members, Superintendent Attorney Dewey Brito. On behalf of Chair Dr. Michelle Stork, I'm happy to share the CSI fourth quarter work. The way the CSI was organized this year, they waited to make any recommendations to the board until after a full year of review. That gave them the opportunity to analyze data, have multiple presentations, and dig deeper on some of these critical issues. The 2 areas in the strategic plan that they focused, one was workforce success, and one was in the area of the increasing academic achievement for all students. The committee yielded 5 recommendations in its closing meeting at the sum of the year. So the 5 recommendations that have been made. The first is the committee recommended for the board to explore a third party or external agency for exit interviews and other data for instructional staff leaving the district. The second recommendation the committee made was recommending for the board to explore coding and theming the climate survey data for the benefit of developing a shared understanding of what that data, what those data are. The third recommendation by the committee was to recommend that the district better operationalize the climate survey process to include a response of what actions are being taken based on those data. The final two recommendations were in the area of academic achievement. The committee recommended the district look at reassessing the data collected from ELL students to track program exit rates with a focus on English language proficiency. And the final recommendation from the committee was the committee recommended to ask the board to ask the superintendent to explore different ways for ELL students to achieve success and potentially put together an exploratory committee to support that effort, such as summer programming, reviewing what other districts are doing, the effectiveness of existing paraprofessional support, what is working, and how do we know. And those were the 5 recommendations that the CSI committee made for this calendar year. Thank you.
Thank you, Dr. Savage.
Thank you.
Next up will be Curriculum Advisory Committee.
Good afternoon, Bethany Quisenberry, Staff Liaison for Community Curriculum Advisory Committee. We met twice since our last presentation here, March 27th. At our March meeting, the curriculum directors with Dr. Spiro reviewed 2 processes. The first topic addressed the edits to the challenge to instructional and/or media materials process. The process was approved by the Curriculum Advisory Committee last school year. The first edit was a parent permission form to be used to allow checkout for any books that was still in the challenge process. The team noted, however, that pending legislation that may result in the removal of this permission form, as the proposed legislation would require a challenged book to be removed from circulation within 5 days of the challenge until a decision by the ad hoc committee was rendered. The second revision was to include a parent permission form for any book that was restricted as a result of the ad hoc committee's decision. There was a lot of discussion around what constitutes literary merit, and more information was requested from the committee about the Miller test. The second process document that we reviewed is a new process involving the new legislation requirements for media purchases. The committee asked that we follow up with a request for more information regarding the Miller test for the April meeting, and there were many community members present and a full hour of public comment on those topics. April 24th was our last meeting. The committee met to receive more information about the Miller test that is used during the challenge to instructional and/or media materials process. The district's legal team, Kathy DePuberno and Corey Hoffman, gave background information on the Miller's test and reviewed each specific component. In addition, we reviewed pending legislation and what it would mean to our current processes. No action was taken, as it was determined that we needed to wait until those legislative updates had been completed. The second part of the meeting was to come to consensus on the media purchase process. The curriculum directors and Dr. Spiro revisited those documents with the committee, and the approval passed without any objection from the committee. There were also many community members present in that meeting as well. Any questions?
Any questions, board? Thank you, Ms.
Thank you.
Oh, sorry.
I don't have a question, I just have a comment. I've watched those meetings. I think you're the liaison. Ms. Giovanelli recommended that we do so, and I was so impressed with staff and your ability and desire to do what's right for kids educationally. And in addition, I was really impressed with the chair. He has like a soft iron fist, if that makes sense. You know, like he keeps order, but he does it in an incredibly nice way. I wish I could be more like him when I grow up. So thank you for your work.
Thank you.
Thank you. Next up is District Advisory Council.
Good afternoon, Scott Hertz on behalf of the District Advisory Council. We have met twice since the last time we reported to you. The first time Actually, we've met 3 times, but 2 of them following the reporting period. We met on March 29th. Unfortunately, we were just short of a quorum for that meeting, which is the first time that's happened to us in some time. But what we did instead of having an official meeting is we still had the presentation, and staff solicited comments from the membership to get ideas on what was going on. We, believe it or not, that was our first opportunity to have someone from the school district's attorney's office present to us the Sunshine Law, and that occurred obviously due to Hurricane Ian and the impact on having those meetings prior. We then had a presentation on Naviance from Candace Alvero, and that was an excellent presentation where a lot of feedback was given in terms of opinions, obviously no official recommendations, but in how to best lay this out and raise these issues to the interested stakeholders, both for students and parents, and to talk about sort of the dual track you have there of teaching our students what they need to do to be successful, and also educating their parents and support givers in what's necessary for those children to be successful, because let's face it, they're children, right? They're not, our children, including my own, are not all, as they grow up, the most reliable or steadfast in honoring their commitments. And one of the great things about these tools is it helps the people supporting them understand what these students need to be successful and how to encourage their students to get there while still holding them accountable for doing that. So we thought that was great. We continued providing the feedback on that, and suggestions were made on how to roll that out, and also thoughts about incorporating some sort of family nights at local schools and things like that to show that, because at all grade levels, that's a wonderful tool to help prepare children for the steps that are coming next. So that was the March 29th meeting. At our April 26th meeting, we had a presentation on the strategic plan, and upcoming thoughts and feedback was given from our various groups. And it's interesting that because we break out into the 3 different breakout sessions of the elementary, middle, and high school, you actually saw that those groups had different priorities. And so I would encourage you to look at those minutes. Again, as I've told you before, we have continued to meet by Zoom and really use those tools for the collaboration. We have a very large council or committee, and we solicit a lot of feedback that way, and we always include in our minutes as part of both the Sunshine Law, but just because it's useful and effective, the Jamboard tool that we use. If you haven't seen the Jamboard tool, it's essentially like an electronic version of Post-it notes, or a board that you would use in a facilitation meeting to capture ideas, and that's all captured and attached to our minutes, so you can read each of the individual ideas that you got to see how they play into your strategic priorities. The top priorities that you got from the elementary group was, the top priority was retaining highly qualified teachers, then providing engaging classroom instruction, and ensuring equitable learning environments. From middle school, again, the first priority was retaining highly qualified teachers and engaging classroom instruction, but then it moved to preparing students for life after graduation instruction and student development courses. And ironically, when you got to high school, that was the top issue. The number 1 priority was preparing students for life after graduation, then retaining highly qualified teachers and providing engaging classroom discussion. So it's interesting how you see all 3 sets have very similar goals, but as their children get older, they become more focused on what is next. And there was some more detail provided that the district should focus on things like financial literacy, as opposed to just the standard math classes. We find our kids are taking algebra and pre-calc, even our kids in ACE and dual enrollment are doing these advanced maths, but they don't know how to balance a checkbook. They don't understand what that is. They don't understand what will be required when they get their first job and they have to file their first tax return and things like that. They don't understand credit cards and credit card interest and what the meaning of those things are. And people are apparently not teaching their kids these things, or parents are not teaching a lot of kids these things. And so, unfortunately, I think the school district still has a duty in local parentis to continue to educate our children about that. And so a lot of that information came forth. I would really encourage you, particularly for that second meeting, to look at the Jamboard notes as you go through your strategic planning, because it gives you a direct feedback, just like you would get when you hire consultants to do a town hall for you. You're getting direct feedback from your constituents and stakeholders about what the important items are, and that's what I think this committee helps bring to you or give to you. It is with some sadness that I tell you this is probably the last time I will be officially in front of you. I've been on the committee for 12 years now. I've been the chairperson, I think for the last, it's either 4 or 5 years I've been the chairperson now. I've worked with a number the existing, I'll say, not your newer board members haven't been a liaison to the committee since I've been here, Mr. Pearsons and Ms. Fleming, but Ms. Jordan, Ms. Patrica, Ms. Giovanelli, I had worked with Gwen Gittens, I've worked with Ms. Morgan, all of them as you rotate through the committees in my years on the committee and my years on the executive, I've worked with a lot of you, and I want to leave you with the thought to please don't let this committee go back to what it was when I first joined. Some of you newer board members haven't heard my little pitch, so if you'll indulge me, I'll take a minute and tell you when I first started coming 12 years ago, and no disrespect to the staff that was doing it then. In fact, I want to specifically give a shout out to Dr. Carlin, Dr. Spiro, and Dr. Cupid McCoy, who's continuing to carry the banner forward. These are not the folks that did what I'm about to talk about. They all worked with me to make this a synergistic process. But 12 years ago, when I was with board member Patrica, back when she was just a parent sitting on the DAC committee, they would invite us to come to the DAC. You would have no idea what the meeting was about. You would show up. Staff would do like a 20-minute PowerPoint presentation and say, any questions? Thanks for coming. Go tell people about this. And that was it. How did that in any way improve what the district was doing? Today, presentations are sent out to all of the members ahead of time. Many times they have the opportunity to share those with their SACs. A lot of times they do it electronically and they get feedback and questions from their SACs that they bring to the DAC committee. We have a list that's been provided to you, I've talked about in previous ones, of best practices that have been developed. One of the ones I'm most proud of that sticks in my head was Google Classroom. During the pandemic, when we talked about how folks were using Google Classroom, and there were a lot of complaints from parents about this is terrible, there were other people saying, this is the best thing since sliced bread. There's a clear agenda. I know what the homework assignments are. My child can find out what's going on. Gosh forbid my child misses a day of school. Here's where things are. This is done. And it's because some teachers use the tool in a phenomenal fashion. And what we did is we gave feedback on that, enabled the district to say, let's find the teachers who do this really well. And at that time it was Dr. Spiro. We worked with the staff and they worked with your teachers and principals to develop that best practices and laid that out. And I know that schools are still using that. Right? It doesn't matter that you're in person, you still have this great tool which is prepping them for what happens when you go to college. And all of your classes are in Canvas or Blackboard. That's where your syllabus is, that's where your assignments are, that's where your responsibility is, and now we're starting to teach our middle schoolers and our high schoolers how to go forward. So I hope you don't lose that. I hope with me moving on and the passion I have that I've tried to bring to this, to work with the district and work with staff to keep bringing forth these new types of things, I hope you maintain that synergistic back and forth, that it's meaningful feedback and it continues to help the district. And I appreciate all the work. I appreciate Attorney Dupree Bruno working with us to enable us to comply with Sunshine and still maintain the electronic forums we were using to capture all this data. Again, if I was in a meeting with 10 people, I'd rather be there in person. I'd rather look at everybody. 20 people, I'd rather sit around a big table and talk about everything. When you get 100 people and you're trying to get feedback from them, sitting in person and trying to get 100 people to all give you a comment, obviously it's very difficult to do. So I really appreciate that and will encourage you to keep doing those things. I've certainly told Dr. Cupid McCoy that she's got my contact information. I'm moving on. I won't have a child in the district. My daughter is leaving. She's going from North High School to full-time dual enrollment at FSW to take advantage of those programs. So I won't have a school to represent, so I won't be on the committee, but I'm still definitely an interested citizen. I've devoted a lot of time along with a lot of you folks to doing that, and I stand ready to answer any questions you might have. And thank you for giving me the opportunity to have been involved in our district, and hopefully we've all worked together to make it a better place.
Board member comments, questions? Go ahead, Ms. Giovanelli.
Okay, you're going to have to come back periodically and say all that again. Or we got to use it as a commercial, and if permission to use it, because the insight is, you can't even put a price on it, okay? Because the change and moving forward, I just love your passion. I just want to thank you for your service, and there always is room at the table for you, so thank you.
Thank you very much.
Ms. Jordan?
I was going to say similar, because I had heard this probably a month ago, which I was hoping it wasn't true, and I was like, well, he hasn't said it yet, so obviously he's not going anywhere. But thank you for everything that you've done.
Ms. Patrica?
So, in a very timely happening of events, I guess, our last agenda item for today's briefing is all of the new policies that we will be adopting. And I need to talk about DAC because the policy for DAC to be approved says that people show up and receive information. That's it. So I have it in my notes here to discuss today so that we can continue to do exactly what we have been doing. You and I have worked together for 3 years. I have already gushed about you, Scott, both to your face and behind your back. But more importantly, your colleagues on DAC had an awful lot of really nice, really supportive things to say to you, as did staff. And you pushed staff hard. As the chair of that committee, you pushed staff hard, but you were always respectful. And it was always a productive kind of pushing. It was never critical for the sake of being critical. It was a real parent life experience that you brought to this committee. And I am just beyond grateful to have made your acquaintance and to work as closely as I did with you. Thank you very much.
Thank you. Thank you.
Good afternoon, everyone. Chris Blakely. Have the pleasure of serving as the chair of the Equity, Diversity, Advisory Committee. And since our last meeting, we've had the opportunity to meet in April and in May. Our meetings in April really took the time to discuss potential legislative updates that impacted the district as related to diversity, equity, inclusion. And in May, as it is our practice, we met as a committee to discuss a review of the academic year and provide recommendations to the board. So for this quarterly report for the fourth quarter, I will be reading through the recommendations that were made by the committee during that May 8th session. The first recommendation, as based on the presentations we received throughout the academic year, was related to Small Business Enterprise Program. EDAC recommends to the board to establish annual goals for prime contracts for minority-owned bidding, receiving a quarterly report from Small Business Enterprise that outlines training hours, bidders, bid recipients, ongoing training of non-bid recipients. The quarterly report should include demographic indicators to identify outcomes of minority-owned businesses as it relates to the Small Business Enterprise Program. As it relates to the Student Code of Conduct, EDAC recommends to the board to synthesize the Student Code of Conduct and establish a mechanism to ensure equity by minimizing administrator discretion, providing clarity of infractions with sanction guidelines. Additionally, EDAC recommends to the board to provide annual training on the Student Code of Conduct for staff, faculty, students, and families. The Student Code of Conduct should be made available both analog and digital with clear access, considering landing pages of the website of the district, focus, and bulleted appendices as otherwise noted. In regards to the proximity plan, EDAC made a statement that the term grandfather clause has roots in America's racial history linked to specific sets of 19th century laws regulating voting. EDAC recommends the board reevaluate language used in communicating the proximity plan to families and communities. Further, EDAC recommends the board to produce an annual report of the proximity plan to include, but not limited to, financial implications, including cost savings, how funds will be redistributed within the district, data on the propensity of resegregation, and provide opportunities for exceptions and extenuating circumstances following the review. Lastly, the committee provided a recommendation related to legislative updates. EDAC recommends to the board to provide the committee with legislative priorities as it relates to diversity, equity, inclusion before, during, and conclusion of legislative sessions. Additionally, EDAC recommends the board be proactive in articulating proposed and passed enacted executive orders, legislative updates, laws related to diversity, equity, and inclusion. This process should be established to articulate interpretation and implementation as it applies to Lee County Schools policies. EDAC lastly resolves that the board support in word, practice and in policy to ensure all students are granted equitable environments for learning and stand against any future proposed legislation that does not embody the principles of diversity, equity, and inclusion. And that will conclude my quarterly report, and I take any questions or comments.
Board members, comments, questions? Ms. Jordan?
First of all, Dr. Blakely, thank you for all you do. And I know I sat in when we did the legislation, had that conversation and the concerns that everyone had at that time. And I will tell you that Ms. Morgan, being your liaison, has brought these to us. So I just wanted you to be aware of that.
Thank you.
Ms. Patrica?
Yeah, and I want our board committee members to understand that there's a process for these recommendations that you bring forward to us. We're not going to respond to them and say yea or nay today. We essentially hand it off to the superintendent, and then his staff does some work on it, and they bring it back to us for approval or denial based on the research staff has done. So I want you to understand you're not getting a response from us, but that doesn't mean we're not hearing you and we're not working on what it is you're recommending.
Yes, ma'am. We're fully aware about the data tracking as far as the referrals and the recommendation that goes in tracking. So we want to make sure it's officially documented. So
Excellent.
We're aware.
Thank you.
Thank you, Dr. Blakely.
Thank you.
Next up is Finance Advisory Committee, please.
Darrell Teblum, Chairman of the Financial Advisory Committee. The Financial Advisory Committee's been having a very hard time making quorum. At our April meeting, we were unable to make quorum, but instead of just calling the meeting, we did have an informal presentation on impact fees, and Mr. Novinsky came forward with a few recommendations, but we were unable to vote on those as well. They're listed in here to have Dr. Bernier and Dr. Parsons have discussions with the Lee County Commissioners and the county manager where to go forward with impact fees for the district. They'd like to have someone from the legal department or planning department work with the board and explain proportionate share and how we can use it to find land for new schools, and request that the planning division report to the school board on a quarterly basis and identify new developments and student growth and the ultimate possible need for new schools. In May, we had the same problem. We were unable to make quorum at the beginning of the meeting. We worked again with the impact fees. The process for impact fees was discussed, as well as certain amounts, and the amount collected at 55% of the rate. At that point, the committee discussed what the requirement is for quorum for meetings to do business, including just voting on minutes and recommendations to the board. At this time, this is going to be my last meeting as the chairman of the FAC and a member of the board. I did want to thank 3 people during my time. I've been here for over 7 years. I'd like to thank Kelly Leckler, Mrs. Jordan, and Ms. Patrica. All 3 of them have been available during meetings and anytime I've ever reached out to them. I can't think of 3 more deserving people that looked out for the students, the staff, and the stakeholders, and everyone is very lucky to have those 3 individuals. If anybody has any questions, I'm here, but that's about it.
Questions, comments? Ms. Jordan?
I would just like to say thank you so much for your service, as well as, and I know serving on that committee as well, how hard it has been to make quorum for years now. And that is something that we keep trying to strive to get people to join, and the importance of the advisory committees. So I just want to thank you very much.
You and Ms. Patrica set a really high bar on attendance, and it made a big difference when you were able to give such thorough representation to the board. It's been unparalleled for all the years I've been on there. Ms. Gittens did a really good job as well, but she's not here to thank. Thank you. Any other questions?
Okay. Thank you for your service, Mr. Teblum. Any other general board comments or questions before we move on? Okay. Just want to thank everyone, especially the committees, for giving a voice to the community, and thank you for your service to our district. I truly appreciate that. Next up on the agenda is item number 2, social media litigation. I'll turn it over to Attorney Dupree Bruno.
Thank you, Mr. Chairman. We have two attorneys who are joining us today to review and discuss potential litigation regarding social media. Mr. Cutler from Wagstaff and Cartmel is here, and I believe that Mr. Kiefer is on Zoom. Oh, great. There he is. And we also have Mr. Makwa from the Mayer Law Firm as well. If you want, you can go up there if you want to.
Thank you.
And these attorneys are going to talk to the board about social media litigation.
Thanks, and proceed whenever you're ready.
Council, thank you. Superintendent, board members, thank you for welcoming us here today. I'm Michael Cutler from the Wagstaff and Cartmel Law Firm.
Could we just make sure you're on the microphones, please?
You can sit down. You're not in court. You're
Yeah.
fine.
I'm not very tall, so I'm not sure if you can see me behind the monitor. Is this?
Is the mic?
There we go. How's
That's
that?
better.
Thank you.
Thank you. So again, thank you for welcoming us here today. I'm Michael Cutler from Wagstaff and Cartmel, joined by Matt Mokwa from the Mayer Law Firm, as you can see on the board there, and then by Zoom, whose face was on the screen to the right of the board. It was John Kiefer, also from Wagstaff and Cartmel, appearing remotely. Thank you all for your time today. I know we've got limited time, so I'm not going to belabor a lot of this presentation. There's a lot of information here. Kind of want to get through that so that we can answer any questions that you might have. I'm also aware that the board, I believe, is already at least somewhat familiar with the social media litigation and kind of the, well, I guess the fact that it's going on and perhaps some of the claims and all of that. So again, we'll kind of go through what we've got here, and then if there are particular questions, we can answer those. So to start, I think one of the things that's helpful as we look towards the social media litigation is kind of looking back at a litigation that's just wrapping up, which was the Jewel Labs litigation. Lee County was part of that. We've talked about that. We represented Lee County in that litigation, and I think we've had a good result there. The social media litigation, as you'll see, kind of has similar theories, and although it's a very different mechanism, social media versus a vaping device, the kind of the goal of the companies and the claims themselves, I think, end up being somewhat similar. So that with that, as I mentioned, we did represent Lee County, as you know. We represented, I think, 21 school districts in Florida in the Jewel litigation. And so, again, that was just wrapping up. Additionally, our firm represented, other large school districts across the country. And here's a representative sample of some of those, going from LA Public Schools, which has about 1.4 million students, through, we also represented school districts throughout the country that, had, I think, fewer than 500, fewer than 200 students. So, school districts of all sizes and types. But what we did find in this litigation, the Jewel litigation, was that whether you're, LA, New York City, a rural school district in Kansas, Indiana, something like that, it was a common issue, a common problem that they all dealt with. And the way that they had to deal with it is different depending on the school district, but the problem itself presented itself in the same way. And again, I think that there are parallels with the social media litigation, which we'll talk about. Again, much like with vaping devices, where we had Surgeon General's advisories in 2014, 15, 16. Even just last month, there's a Surgeon General advisory about social media and the impact on the mental health of the country's youth and adolescents. I think it probably comes as no surprise to everybody, the extent of usage of particularly youth and adolescents on their devices. I think we've all seen it probably. I know I have with my own kids, but it's a real issue, and I think it's not just an issue that parents deal with. It's an issue that's being recognized, even by the Surgeon General. Again, this is just from May 24th, so a few weeks ago, the Surgeon General talking about the profound risk of harm to the kids presented by social media, okay, and the need to take action to prevent future harm and addiction. Social media boom, these are some numbers here. So almost half of high school students report using social media daily, which, I actually kind of find surprising. I think that seems low to me, but that's that report. And 1 in 4 teens report being online almost constantly, which that seems probably also, to me, seems a little bit low, but I certainly believe that it's at least that. We're all familiar with Facebook. Now, Facebook is obviously was its own website and app and social media, but Facebook also owns, or I guess the larger company also owns additional social networking sites. So here, Facebook, for example, largest family of social networking sites, had 100 million users in 2008, and that's almost 3 billion users 13 years later. The thing about these social networking sites, obviously it's free to create an account, and so what that means is that the companies that are putting the product out have to have a way to make money, and that's going to be advertising. And so I think we see here $115 billion in ad revenue in 2021, 98% about the total revenue for social media companies is going to be advertising. So obviously with all the money coming in through advertising, the way that you make that time valuable is you got to keep the kids on the social media. So they've devised ways to do that, and we'll talk about that a little bit. But again, it just drives attention, eyeballs, and that's going to drive advertising and revenue. So a couple years ago, about a year and a half, almost 2 years ago now, there was a former Facebook employee who, is kind of a whistleblower. I think probably what she said probably doesn't come as a huge surprise to people, but I think it's shocking to have somebody from inside of the company, come out and acknowledge some of the strategies and some of the techniques and goals of the social media companies. Again, Frances Haugen, she was a former Facebook employee. What she said is that Meta, which is a company that owns Facebook and Instagram and various other things now, identified psychological vulnerabilities. They hired teams to exploit those vulnerabilities through technology-driven behavioral manipulation. Meaning what? They've devised algorithms that will attract kids and, like we said, keep them on the social media. And if you've seen kids with their phones, sometimes it can be disconcerting, kind of the endless scrolling. And I mean, it seems like it will just go on forever, and that's because it will. It's designed to do that. And it's designed to go on forever and to present something to them that they want to see, to keep them engaged with the application. So, right, Ms. Haugen, acknowledged that Meta or Facebook long knew of the impact on teens, especially teen girls, and still knowing all of that, kind of, still went through with their plan and all of the programming and technology manipulation to essentially addict or hook kids onto the social media platforms. Again, here's some numbers which are probably not surprising, but are still no less, I think, infuriating, maybe. But internal documents from Meta, kind of show that they had a pretty good handle on the extent of the issue that kids were facing, and again, hadn't done anything to try to mitigate those effects from their platforms, and instead, again, are able to sell more advertising because they're able to keep the eyeballs on the screen and on their platforms longer. Use of different media applications. So 95% of children use YouTube. Not surprised by that. 67% of children use TikTok and 59% using Snapchat. So the vast majority of youth are using these social media applications, which again probably doesn't come as a huge surprise to everybody, but when you kind of see it and think about it, it is a little bit staggering, the amount of time that is spent with some of this. So after following some of the revelations about the way that the companies are using their technology to manipulate and to hook people onto their social media, there is litigation going on in California. Much like with the Juul litigation, the social media litigation is consolidated. The federal litigation is consolidated in the Northern District of California, which is where the Juul litigation was as well, although this MDL is in Oakland instead of San Francisco. In any event, that one is consolidated there. Then there's another state court proceeding in California, which is similar, but it's in state court rather than federal court. Our lawyers are part of the leadership of the consolidated proceedings. So we have people on committees. John Kiefer, who is with us virtually, is on committees. Tom Cartmel who is the lead trial attorney for San Francisco Unified during that trial with Altria, which just wrapped up. He's on the steering committee, and so we're involved in the leadership, and we'll be taking a substantial role again in the litigation, much like with Juul. The defendants in the social media litigation, again, Meta, we talked about that. They've got Facebook and Instagram, Snapchat, TikTok, which is actually a company called ByteDance, and then Google, which has YouTube. Again, kind of alluded to it, but the addiction, I mean, it may seem a little bit odd to use addiction with, looking at your phone and using a social media application, but if you've seen kids using it, and adults too, I mean, it's not just kids, and adults too, you can see, it is compulsive, it feels compulsive, any waking second that there's not something going on, you see people often look at their phones, they're scrolling through, you see the kind of the endless scrolling motion there, and it is, that excessive compulsive behavior, it is associated with mood alteration, behavioral issues, that type of thing. So, it looks like addiction in all of its forms, even though it might not be a traditional medium that we would associate with addiction. Again, some of the symptoms that we see and that we've heard about, we talk to school districts, we talk to people, mood modification, salience, tolerance, withdrawal symptoms, interpersonal problems. These are some of the things that unfortunately kind of go along with that compulsive use of social media. And it's not just the fact that you're scrolling through. It's also what's being delivered to you as you're scrolling through, and that's a big part of this, which is the the way that the technology is built, the way that they develop it, is to feed essentially kids or also older teens, adults, feed them kind of what would interest them. And so a lot of times that's can kind of get into the negative, some of the subject matter, and then it just kind of doubles down and kind of builds on itself, and the feed, the social media feed just kind of keeps building that way. Some of the consequences of addiction, academic performance, sleep disruption, anxiety, depression, I think some of these things are, again, probably not a huge surprise in terms of some of the consequences. There are things that these platforms could have done differently, if the goal were to protect the youth, rather than the goal being to drive as much advertising revenue as possible, get as many eyeballs on your application, on your platform for as long as possible, as often as possible. So if the goal were to protect youth, there were things that they could do, like simple things like limiting the number of hours that can be spent on the social media platform, limiting notifications, limiting the targeted marketing, right? I mean, that's part of the big part of the technology and part of the algorithms that they built was this targeted marketing to the minors. There are things that they could do with social media influencers, different limiting features that they could use with algorithms, but there are a lot of things that could be done differently if the goal were to truly protect youth. So again, much like with the Juul litigation, schools, because schools is where youth spend the most of their time that's not spent at home is spent at school. And so schools, unfortunately, are going to bear the brunt of some of these kind of new and novel issues that have come up, like vaping, like social media addiction, all of that, those behaviors. And there's also, I think, some sense that students feel like they can kind of get away with things at school more. There are more people, their peers around, all of that, than perhaps at home for some of them. And in addition, to the extent that this is an addictive behavior, you start to see that compulsory behavior in school, even when it's not appropriate, even when you're not supposed to be using it, that type of thing. So what happens with schools, again, much like even with vaping, there's a negative impact to the educational process, distraction, and we found the distraction, as we've talked to school districts, distraction is for everybody, right? It's for the teachers, other students, administrators. It just kind of creates an issue where there used to be none. So here's this new issue, and now everybody has to deal with it. It's a drain of the resources. It requires additional student support services. It requires more intervention and policing, investigation, that type of thing. And I think, even more so with social media than with something like vaping, I think the privacy concerns and all of that, and part of the investigation, I think that's all, makes it very difficult to deal with. There is an economic impact. I think, again, that kind of comes with a lot of the diversion of resources and distraction. Schools have spent money or reappropriated funds to help try to train people, hire people, come up with different ways to deal with social media and with some of the issues that the students face because of the social media addiction. Monitoring, there are things to keep students off certain sites during certain parts of the day, that type of thing. But I think it's much like with vaping, it's a big problem. It affects a lot of people, and it is tough to deal with. So what we've seen is this is starting to gain steam very quickly with school districts, and it is, something, again, when we started talking to school districts, which we had already been talking to because of the Juul litigation, we've started to talk to them a little bit about social media. We've started to kind of really start to understand the scope of the problem, because, again, school districts across the country are all dealing with it in different ways, but they're all dealing with it. And so here, here are some schools that have joined the litigation against the social media companies. The bold ones there are obviously Florida school districts. And as you can see, as I mentioned, there are school districts, big and small, spread throughout there. So again, it's a problem that permeates throughout. In the litigation, the model is similar to the Juul litigation. I mean, essentially, it's like I mentioned, it's the same type of problem. It's a public nuisance, meaning that it's something that was created, and now school districts have to deal with it. They're dealing with it in a way that's different than just the general public, because they have this captive audience, and they have to monitor students. They're responsible for student health and safety and all of that throughout the school day, which takes up a large chunk of the year. And so, the impact to schools fits with the same type of public nuisance legal theory that was utilized in the vaping, the opioid epidemic. That was the legal theory there in the 90s to fight the original tobacco companies, which led to the Master Settlement Agreement in 1998. It's all kind of part and parcel of the same theory. So again, public nuisance litigation. So details of school district litigation or representation in the litigation. Again, about our firm and our group, we've had a lot of experience with these types of litigations, this multi-district litigations, and we've got the experience, we have leadership, we've got all of the people to handle all the parts of it. For the school district, there are no upfront costs or expenses. The school district would just be required to pay expenses on the back end if there is a recovery, and same with attorney's fees. We work on a contingency basis, and so the fees would be paid only if we obtain a recovery, and that would be at the end. And I think, much like with the Juul litigation, there's not a whole lot of, after filing the lawsuit, there may be, typically there's a fact sheet, kind of a informational sheet that the school district would need to fill out, and typically that's about it, except for a small handful that are kind of picked to go through a little bit more of the extensive discovery process. Those would be the bellwethers, and that's something that will be figured out later on throughout the litigation. So I know I was quick, I tried to buzz through it, hopefully not too quick there, but I did want to save some time for questions, so hopefully there is some time for that.
Thank you. Before I proceed to board comments and questions, does Attorney Dupree Bruno need to go over anything or outline anything before?
No, Mr. Chairman.
Okay. Questions, comments, board? Ms. Jordan?
I hear what you're saying, and of course, I think that kids should not be on Facebook or TikTok or any of those as much as they are, and that includes adults as well. But how do we prevent that from happening in this suit?
Well, and John is on as well, and I'd welcome his thoughts as well, but how do we prevent that from happening from this suit? Well, I think the point, for each school district would be a lot, like with the vaping is, so how do we develop programs, to, whether it's mental health programs or intervention programs, there's a monetary recovery component, which I think, that's kind of self-explanatory. That's for the school district, right? And so, whatever programs you want to develop there, and I think, throughout the course of the litigation, like with vaping, for instance, we worked with people to develop some of those, options for dealing with the issue. And so I think a similar thing there. I think there's also the possibility for injunctive relief. you know, and certainly something that we would want to see against the school district, or against the, on behalf of the school district, against the social media companies. You know, again, maybe it's putting into place, you know, certain limits, or, you know, there are a lot of different things. There was a slide about what could they have done differently, you know, to help protect the youth. I think some of that could be an injunctive type of measure. And then I think the other, you know, the other recovery potentially in a lawsuit like this would be punitive damages, which would be a financial penalty, you know, in which, you know, hopefully would deter the companies from doing something similar again. And so I think it's going to be, you know, I think it's a difficult issue, and it's difficult to prevent, but I think education, intervention, you know, and holding the companies accountable, I think will kind of encompass that. And again, I don't know, Matt or John, if you have additional thoughts on that, but I mean, that's the big question there. Yeah.
Just use of funds, I'm good with that.
Okay.
Ms. Patrica.
Thank you. So you went through the costs, and I know I asked this question last time, but I'm forgetting the answer. No cost to the district whatsoever if we lose, to include that, I keep forgetting the name of the fee that the court imposes in this kind of litigation.
The consolidation benefit.
Thank you.
So there's, right, so the costs in a lawsuit would be obviously the filing fees, and then you mentioned in MDL's multi-district litigation, they have what's called the common benefit assessment, and that's usually a court-ordered fee. And that's correct. There would be no common benefit assessment if there's no recovery, and the school district would not be on the hook for I think it's probably a few $100s for filing fees in the event that there's no recovery.
Okay, that being said, I don't see any risk to us at all in joining the lawsuit. I think we talked about this last time. The potential benefit of recovering assets for us to use for our students' mental health benefit is great. I like the injunctive relief piece of it as well, but I think your problems of proof are significantly higher here than they were with Jewel. If you go back to that slide, and you don't have to, but if you go back to the slide that talks about the various things that social media does, as parents, we have the ability to remotely control a child's access to social media. So with parental rights comes responsibilities, and I don't know that we had that ability or have that ability to remotely control their access and use of a Jewel. But we do have, if we're paying the bill, we can control and limit or block their access to social media. So I see that as a huge issue here. That being said, good luck. I hope that you recover for our kids. I think the next question, if I may, through the chair, is for Attorney Dupree Bruno. What is the negative impact to the district for waiting 2 weeks to approve this? And the reason why I asked the question, you and I had this discussion in our one-on-one, is we have a process in place, generally speaking, where we're briefed on an item and 2 weeks later we vote on that item. I'm always very resistant to violating any procedure, because I think procedures are in place to make good decisions. And I also, you know, we've had 2 law firms come in front of us, and I'd like the time to receive feedback from the public if they have any. So why the rush? What is the negative impact to having this be placed on the agenda in 2 weeks?
I don't think it's a rush, Ms. Patrica. The school board was actually briefed on the social media lawsuit before questions were answered, and the board directed me to move forward with retaining counsel. And in reviewing and talking to some of my sister districts and other councils, I would recommend that we move forward with Wagstaff and Cartmel, because Wagstaff is the firm that represented us successfully in the Jewel litigation. They are also the firm that has been on the front lines in terms of actually doing the litigation in front of the court. So I don't think there's a rush. This would be my recommendation. And normally with contracts and other attorney recommendations, we're not necessarily waiting for the public to tell us which law firm to choose. It's going to be based on the law firm's experience and what they have done for the district in the past, and that's what I'm putting forward, if you will, in terms of my recommendation. And also the other concern that I have is that some districts in the Jewel litigation were kind of like the tag-along cases, and some of those districts did not get the same amount of settlement in terms of the calculation. It's my understanding. Could you guys please explain that a little bit? Because I know that some districts were later in terms of joining the litigation versus us, who were one of the districts that was on the forefront, even though we weren't a bellwether, but we were certainly part of the discussions and the negotiations. Can you address that, please?
That's right. So for the Jewel litigation, there were, I can't remember how many categories, but essentially they categorized, you know, by when you filed, you fit into one of 3 or 4 groups. And that was one of the factors in the allocation of the overall settlement. So later filed school districts or government entities, you know, that were in that kind of category received a lower allocation than earlier filed. Having said that, you know, I don't know if, and not to deter anything, but in full disclosure, you know, I don't know that the 2 weeks here will make all of that difference, but it is true that, you know, as time goes on, there is a potential that any further, or you know, any future settlement allocation might be reduced. That's all.
And the only other thing that I would add to that, per our sunshine rules, obviously, when we're making recommendations, there are contracts, those have to be properly noticed and placed in advance on our agenda for the public to be able to review it. So this was placed in advance, so any member of the public can come tonight and make any type of comments that they want at the action meeting.
Okay, if may I?
Briefly.
Okay, thank you. So hearing that there's no negative to the district in waiting 2 weeks, I personally would feel more comfortable in waiting, and it's not because I want the public to tell us who to hire. I don't believe the public generally tells us what to do, but I do think that it's important for us to give an opportunity for feedback. So I would just ask that, just if no harm, no foul, just wait 2 weeks and put this back on the agenda in 2 weeks. That would be my request. Please and thank you. Those are my comments.
Mr. Persons.
Yep. I'm just saying, we heard this before, and I got a lot of feedback. It was all positive that we should proceed from the first one. It was not public comment, but through emails and calls, you know, I think we all realize that the social media, to me, is a bigger problem than the Jewel. And I think having the social workers and psychologists better funded and the programs better funded, to me, I want to proceed as soon as possible. That's just where I'm at. I think I'll stop there.
Any other questions, comments? Okay. No? I'm good. I'm content with moving forward at this moment. I agree with what's being said. I personally have a little bit of concern in regards to being able to prove the damages, but that's your job and not mine. So I agree with what's being said, and unless there's anything else, unless anyone has any other objection, I believe we should move forward. So, any other questions, comments? Attorney Dupree Bruno, do you need anything from us?
Just want to make sure I have clarification. Does the board want me to wait 2 weeks, or the board wants me to bring it at the action meeting this evening? Because it's already on there. If we're going to wait, then I'll pull it.
Does anyone want the item pulled? Go ahead, Ms. Juvenile.
We haven't really heard if the public has an opportunity to speak on it. I think we should certainly have that opportunity. I'm on the fence. So there's no penalty. It's not gonna hurt us to wait 2 weeks. That's what I want to make that clear. We're not gonna, if we waited 2 weeks to vote on it, would that be a detrimental to your case or our case?
I don't think so. No, I don't. And again, I know John Kiefer is on Zoom, and John, I would invite you, if you can hear me, if you disagree, to speak up. But I obviously.
I don't think I can. Yeah, look, bottom line, I think the board needs to do what the board is comfortable doing based on their process. From our standpoint, 2 weeks isn't going to make a difference in how this litigation will end up and any recovery to the board. We think the litigation has a lot of merit. I won't repeat the points Mike made before. We are aware there are other law firms out there. We think we're the best choice for a number of reasons. We're leading this litigation as we did in the Jewel case. We were lead trial counsel there, negotiated the resolution, and represented more Florida school districts and more large school districts nationwide than any law firm in the country. It's the same situation here. It was our absolute privilege to represent Lee County in that litigation. You were one of the first school districts in the nation to step forward there. And it would be our absolute privilege to represent you again. But no, 2 weeks, if that is makes folks more comfortable relative to how you ordinarily reach decision on these, it won't have an impact in how the litigation turns out.
So also this PowerPoint, I was looking through the information that I received. I didn't see that. And I wanted to see the list of those that you're already representing, and it went real fast.
So
Possible?
I'm happy to go back to that. Yes, absolutely. And I think we can probably share this. I think council has a copy now as well. Did I skip it as I was talking? I did. Sorry.
And while Mike is pulling that up, I might add, and this is not a complete list, but in the Jewel litigation, we represented Orange County, Hillsborough, Palm Beach, Seminole, Pinellas, Lee, and a number of others. Orange County has voted to move forward with this litigation. Several other smaller districts have as well. I don't want to get out specifically and publicly in front of my other clients, but I can tell you all of the large Florida districts that we represented in the Jewel litigation, this is coming before their boards in the next anywhere from 1 week to 6 weeks. And I'm cautiously optimistic. I think they will all ultimately come on board in this case. So what the slide Mike has for you today are ones that have actually put it to a board vote as of today. But there are a number of others upcoming.
Thank you. My opinion is, I just think we need opportunity for the public to be able to speak on it at this point, but I'm very supportive of it. I just think we have to follow our processes, and that would be one of them, in allowing public to have comment. And if they don't, that's fine too. Thank you.
Mr. Person.
Yeah. Well, I see no harm in proceeding immediately. I also would not object to waiting 2 weeks either. So I'm fine if we want to pull that.
Okay, so where is our board looking at? Do we want to do this tonight, or do we want to do 2 weeks? Do you want to give a indication, I guess, if you want to go tonight?
Should we officially use this as a pulled item and vote on it tonight, I think, since we don't normally, or is this just a recommendation?
So, Mr. Chairman, I would, if the board is not inclined to move forward with this, I mean, again, public can come and talk about it tonight. I don't know what 2 weeks is going to make a difference on, because this is not part of the consent agenda even. This is an attorney recommendation. So they can certainly talk about it, but if the board is inclined to make it 2 weeks, then, I will take it off the agenda and we'll put it back on in 2 weeks. I just need direction from the board.
Okay, and what do we want to do? Ms. Patrica?
So for me, it's a process issue, and I wasn't here for our board self-evaluation, but one of the things you would have heard from me was issues about process. I believe rules and processes are in place to lead to good results, and I think it sets a risky precedent for us to hear a presentation, and the subject matter is similar, but to hear a presentation and vote on it on the same day, it's just not how we function as a board. So from a comfort perspective and from a process perspective, I would ask that we please have Attorney Dupree Bruno pull it and then bring it in front of us in 2 weeks. I'm inclined to vote yes, but you never know what people are going to say to me in the next 2 weeks.
Ms. Jordan?
We have already had I asked a question just to ask the question for you to say we're going to get funds. And as far as, we have already had a presentation on this, I think a month ago, with a different firm, and we had asked for this to be done. So in saying that, I don't understand why. I think we need to move because we have already asked for that to be done. So we're not really violating any process because we've already seen the one, we've asked for our second, and we have received it. So
if I could just add, normally, this probably would have just gone under attorney recommendation without another briefing because the subject matter was already brought forth to the board and the board already directed me to move forward with it. The attorneys wanted to come in and there were some other things they wanted to discuss, so we took the opportunity to also brief the board. But again, it's to the board's discretion. We'll do whatever you direct us to do.
I'm inclined to move forward tonight. Why don't we do a thumbs up if we want to move forward tonight for whoever wants to. Do you have your direction, Madam Attorney?
Yes, I do. We'll move forward tonight. Thank you.
Thank you. Okay. Moving on to item number 3, job descriptions with Executive Director Dodig. Thank you, Mr. Carter.
Thank you all. Appreciate it.
As Mr. Dodig, Mr. Chair, if I may?
Yes.
As Mr. Dodig makes this transition and our lawyers, an additional law firm takes its seat, I'm going to take the opportunity to introduce Mr. Dodig. He is here to really talk about 3 different job descriptions. One is for the Healthy Living Initiative. Specifically, that will relate to the gardens that we're all very fond of. We are getting bigger and more complicated as it relates to those gardens and the support. And there's a desire both with FGCU and with our local ag outreach to expand those garden initiatives. We will need someone to take the lead. We do not have anybody in mind, but wanted to bring the coordinator of the Healthy Living Initiatives to the board so that you could review this as a draft and see whether there was a commitment potentially to move forward and turn it into a job description. The other 2 are minor adjustments and revisions to the coordinator of adult ed and career education. This was provided by members of the adult career and education staff, specifically looking to find minimum calls that would help us better recruit. And finally, the Director of Athletics and Activities. This one is very specific to a certification that we want all of our athletic directors to have, but they cannot have it until they are an athletic director. So if we put it in as a qualification prior to their employment, in many cases, we will eliminate lots of people that would make a fine athletic director, or suggesting, and Rob will go over it in just 2 seconds, we're suggesting is we put it in a different place that requires to get that certification within a period of time. So I'll turn it over to Mr. Dodig.
So I can't really state much more about the first job description that Dr. Bernier mentioned. That is a new job description for Healthy Living initiatives. That will be in academic services. The second job description, we made changes to the coordinator, the minimum quals and the preferred quals, making the bachelor's degree from an accredited institution a minimum qualification and a master's degree a preferred qualification for that position. And then the change to the athletic director, Dr. Bernier is correct. The National Interscholastic Athletic Administrator Association certificate will have to be obtained within 3 years. Currently, to receive the appropriate certification, one has to be a sitting athletic director to be able to take the coursework to do that. So we, as you know, made the athletic directors administrators a year ago and had that as a minimum qual. We've been able to work through the current athletic directors so they can work towards this certification. But currently we're in a situation where we need to hire new athletic directors, and they wouldn't be able to earn that unless they're a sitting athletic director. So I'll take any questions you might have.
Questions, comments, board? Ms. Giovanelli?
How many athletic directors are you needing to hire now? Like, do we lose some?
Not a whole bunch, actually. There's one opening that I'm aware of.
Okay.
At Island Coast High School.
Okay.
Yes.
Thank you.
Ms. Langford Fleming?
That was actually what I was going to ask, Ms. Giovanelli. And I am thankful that you clarified about the certification, because I agree there are some amazing people out there that need to be able to give in this opportunity, but don't have the certification. So thank you for clarifying. That was my only question when I was looking at this. So thank you.
Ms. Jordan?
Thank you. Regarding the coordinator, the adult and career ed,
Yes.
okay, what do they have right now? That person who is in this, is it a bachelor or is it a master's?
This position is vacant, I believe, currently.
It is vacant?
Yes.
Yes, this is the coordinator. This would be the person who reported to the director. He left prior to the announcement that our director was also leaving. He took a position in a county just north of us.
Okay, so what it says, okay, so now I know who it is. I try to put people to this. So instead of a valid Florida certification is what?
That's a certification in ed leadership. That would become a preferred qualification, not a minimum qual.
Okay, because it's crossed off on the top of that.
Right, and it
Okay.
goes down below.
And then if you look at the academic service organizational chart,
Yep.
when you look at that, where is, so the director, that person's not under the director, correct?
This position is under the director of adult ed.
But it's not on the
Correct,
chart.
it's not on the current chart in front of, right.
Okay,
The chart doesn't go down.
it only goes down for the.
We have a chart
for
that
the
does,
chief.
that's just not the chart attached here.
Okay,
Yeah,
I was just trying to put all of those that you have in
Gotcha.
conjunction
Yeah.
with this, and it wasn't making sense to me, because half of it's done and half of it was not done.
It has to do with the level of chart that Mr. Dodig, excuse me, Mr. Chair, I apologize.
Go ahead.
It's a great point. It has to do with the level of chart that's been chosen. If you'll notice that these are executive directors and above, and directors, that the position reporting to the director of career and adult ed would not be a director, therefore wouldn't appear on this chart. We'd have to go to the director of adult education and pull that specific organizational chart to see that structure.
Thank you.
Is that it, Ms. Jordan?
Yes, thank you.
Okay. Any other comments or questions? Seeing none, okay. I appreciate to see the expansion on the healthy living and the gardening program. So I have some family that has some experience in that. So thank you.
thank you.
Next, it's Mike. Next up on the agenda, item number 4, comprehensive health instruction materials. And I believe this is going to be Dr. Spiro and Dr. Quisenberry.
Yes.
And whenever you're ready, Mr. Superintendent, if you want to introduce this.
Be happy to introduce the team. Dr. Spiro, Chief Academic Officer, Dr. Beth Quisenberry, Director of Elementary Curriculum and Instruction, Lori Houchin, the Director of Secondary Curriculum and Instruction for middle school, and Candace Alvedo, the Director of Secondary Curriculum and Instruction for high school. These individuals have a massive task getting us ready for the new school year, one of which is the Comprehensive Health Instructional Materials Annual Review. I think you'll find this enlightening regarding that there's just a pretty straightforward approach today to make sure that you're informed, but I'll let the team share that information.
Thank you very much, Dr. Bernier. With me today, as Dr. Bernier said, I have the Directors of Curriculum and Instruction with me. Our goal today is really to cover 3 topics with you. One is to share with you the State Board rule as it outlines for health education, as well as our instructional materials for the K-12 health instruction, and finally, our parent-guardian communication regarding K-12 health instruction. And the reason we're with you here today is because annually, we are required by Florida state statute to share with you our materials around K-12 health instruction. The board has already adopted and approved the materials that we currently use for instruction. There will be no new materials coming forth. So what we're going to be talking about are materials that already have been board adopted, but we are required annually in a public forum to share with you what those materials are. At this time, I'll turn it over to Candace Alvedo.
So in addition to what Dr. Spiro just mentioned, we talked about annually that we have to report and have our materials approved. There's also 2 other pieces that come before, and that's by December 1st of each year, we have to submit our plans of how we plan on implementing those required instructional pieces. So that has already happened for this school year. And then at the end of the school year, the traditional school year as we think about it, by July 1st, we have to submit what we actually did. So the State Board of Education looks for us to utilize our materials, put together our plan of what we intend to do, and then we submit at the end of the school year what actually transpired. So there are 6 pieces of legislation that guide all of our work around standards, but specifically today we're going to talk about health instruction. The second one is the one we're going to spend the most time with, as that really dives into what's inside of the materials in which we use. One note to make here is most recently there was a change in House Bill 1069 that added additional language in which we need to ensure is in our adopted materials and prescribed for teachers and how we teach components of health education. We have already gone through all of our curriculum maps, scope, and sequence to ensure we're in compliance with new House Bill 1069. And when those resources are published for teachers, after our materials are approved, that will be outlined there as well. Those teachers will then be trained on those pieces when we do our back to school training on August 3rd, so they are also aware of any changes to their scope and sequences. So there are 14 components to the comprehensive health. The 12 that you see here on the screen are common across K-12. So in elementary school, middle school, and high school, these are the 12 areas in which we're all required to provide instruction around. There are 2 additional components that are unique just to secondary education. You'll notice the very first one is specific in grades 6 through 12, but then it delineates one piece further that teen dating violence, that instruction cannot begin until 7th grade. So when we think about the 12 components in which we saw on the slide prior, plus these 2 components, these are the 14 areas in which make up comprehensive health instruction. And with that, I'm going to turn it over to Dr. Quisenberry, who's going to share with you what materials are utilized for elementary school.
Go ahead. Of the 12 required components, with the exception of substance use and abuse, we cover all of those components in Safe and Smarter Kids. So Safe and Smarter Kids, there is a playlist provided for teachers inside of their Launchpad. It's very scripted for what teachers are going to be teaching the students. And there are 6 to 8 lessons. They're around 20 to 30 minutes each. For the substance use and abuse, we use a district created for K-2, and then Generation RX for 3 to 5. Those lessons are just 1 lesson per grade level, and they're around 45 to 60 minutes. Inside of Safe and Smarter Kids, with each lesson, there is a family letter that teachers are able to send out to the families that notify them of what will be included within those lessons. We also send every September of every school year the school messenger that you see, notifying families that we are going to begin Safe and Smarter Kids and the substance and abuse, use and abuse instruction, and it also has links for them to be able to access those lessons.
In middle school, we currently use the Glencoe Teen Health Edition book, and that was published in 2014. And then for the courses that we offer, the board and district requires that 6th grade students take health, and so schools can accomplish this by either offering a semester of health if they have a certified health teacher, or they can do peer counseling and cover the same standards, but that is a year-long course. We do have schools in addition who offer health in 7th and 8th grade as an elective.
So looking at the high school, it's also called Glencoe Health, but it's Florida Edition 2014. So there is a difference between the middle school textbook and the high school textbook. This one, as Dr. Spiro has mentioned, is the same exact textbook in which has been board approved and was utilized this past school year. For high school graduation, it is a requirement that students graduating have 1 credit of physical education to include the integration of health. The 2 courses in which we offer in Lee County to meet that requirement is the Hope Core and the Hope PE Variation. The only difference is how the content is laid out. For some, it is a first semester of all health, and second semester is PE, and in some, it's quarter 1 is health integration, quarter 2 is physical education, then we go back to health, and we complete with physical education. So that's the difference between those courses. Content is exactly the same in those pieces. Something unique to high school, though, is while it's a graduation requirement, statutorily there are ways in which a student can waive taking the Hope course. So the first 2 bullets you'll see there is if a student has 2 years of a JV or varsity, that waives the full Hope requirement. Same to 2 years of JROTC. That's going to waive the full Hope requirement. The next 2, though, you'll notice they're semesters. Because they're semesters, they're only waiving half of the requirement. Therefore, the student would still need to complete half of that integration. The other way a student can waive this requirement is by earning their International Baccalaureate or ACE Cambridge, being a completer of those curriculum. So this is also laid out in our student progression plan for families, and the language details out for students exactly what the requirements are to waive those components.
Part of the legislative requirements requires that parents have an opportunity to opt out of certain portions of health. So at the secondary level, if a parent does not want their child to learn about reproductive health and disease, HIV/AIDS, its symptoms, development, and treatment, there is an opt-out form in which they can fill out, and they'll be given alternative assignments that do not cover those topics. Parents can find this form and our curriculum maps, they're linked throughout there many times so that they don't miss them, but you can also just look in the parent portal under the health opt-out form. And in addition, we train our teachers and we stay on top of it to ensure that about a month prior to that content being delivered, that they give parents the message that we're about to cover these topics. If you would like for your child to not learn those topics, they provide the form again. So we really try to ensure that we're in compliance with that statute.
So that gives you a little synopsis of the health materials we're using, how we communicate with our parents and guardians about the opportunity to opt out. The next actions or next steps will be on June 27th. We will have a public hearing and then an opportunity for the board to vote on the approval of the instructional materials. Again, there's no new materials. These are materials that already have been previously board approved. And now we will have superintendent comments and board discussion. Thank you.
Board members, Mr. Chair, there's really nothing to add. I think the presentation is very comprehensive, very straightforward. I thought the most important thing you needed to realize, and the community needed to realize, that we have no additional curriculum materials. Those that have been prepared and that have been utilized in the past will be the ones to be continued to be used this year. So, looking forward to your discussion.
Thank you. Board member comments, questions? Ms. Langford Fleming.
Just a couple questions that I just personally don't know. If a student gets to the end of their high school career and does not pass that does not receive that IB diploma or that certification, but they also haven't taken the HOPE because they were relying on that, what in turn happens then?
So for that one, it's curriculum completers. So not necessarily having earned all of those, but completed the curriculum there. Many of our students, though, especially in the advanced courses, we encourage them to take that course going into 9th grade for that specific reason. So we try not to wait, because there are many a times when we hit our junior year where we have decided maybe I don't want to continue down this pathway and now I have one more course. So a lot of students will take it right now, summer 8th going to 9th grade, as an online credit.
Okay. All right, thank you. And then one more. Regarding the letter that we sent out, I appreciated I think it was Ms. Giovanelli that suggested, back when we were talking about focus a couple weeks ago, about some kind of a receipt read or something we can send out to parents so that way we aren't, a parent's not calling or emailing, say they never saw that letter. I don't know if that's something that we could consider sending out so that way we have a receipt knowing that, yes, we have sent the letter, yes, you have seen it, or, I'm always open to an opt-in rather than an opt-out, but I didn't know if there's a way to cover our basis, making sure that parents definitely have seen the letter that in regards to what's going to be taught. Those are my only questions. Thank you.
I can get back with you specifically on the read receipt. It was something we've looked into. I've been working with Mr. Alton as well as our communications department. We currently perceive that there is an ability to get a read receipt. We've not yet tested the system. We need to test that, and then we can come back with a definitive answer.
Is that it, Ms. Langford-Fleming? Okay. Ms. Giovanelli?
But I think it's more important that, back to the read receipt, it's the fact that it's something letting the parents know they saw it, or they've seen it, or it's back, that they have to check the box that they've seen it, regardless if they've actually read it, because that's what will be, they may have seen it, but they didn't read it. How's that? So that extra step to say, click, I saw it, is, I think, is more thorough, and versus having to have IT look back and see if there was a read receipt in the system, because I've had computer issues the last couple weeks, and I can tell you that it's not always guaranteed that you're going to get the information, or that your email went, or so forth, because I've had that happen now with my own home computer and this computer here. So some issues. So I think that I just want to be real thorough on that. Also, just a real quick question regarding the waiver options. So they could do 2 years on a varsity basketball team or JV team, and they would not have to take the Hope class, and they just have to be on the team for 2 years? I just want a little clarity on that. Please, thank you.
Yes, so they do need to complete 2 years of a JV or varsity sport. So they need to be part of that team, and 2 years will satisfy that, and that's outlined for us in legislation.
Oh, awesome. Thank you.
Anything else?
I just want a clarification for that question, because I think our community can now perceive that in a couple of different ways. So I'm going to take off superintendent hat, put on a dad hat. Does that mean if my child plays JV basketball and JV baseball that he's completed 2 years, or must he complete JV basketball his freshman year and JV basketball again senior year? In other words, is there a congruency related to the sport, or is it just participation in 2 JV sports? I just see the community asking me that question.
Yep, and I would like to pull the language and specify, because in my brain I know what it says, but I would like to pull it out and give you the exact statute on it.
So Candace is taking a play out of my playbook. We will make sure that we get that answer. We'll put it in the board update. And Candace, I'm sorry to put you on the spot like that, but it was just a question that, no matter how many times I've seen this, it was Ms. Giovanelli's question that sparked that question in my regard.
Good.
I do too.
Okay, thank you, everyone. Before we proceed to item 5, we're going to take a 5-minute recess, please. Okay, resuming our meeting, our briefing. We are now on item 5, 2023-2024 Code of Conduct for Adult Students. Please proceed whenever you're ready.
Morning, board members, superintendent, Mrs. DePoy Bruno. The adult code of conduct has not had any updates since our May 23rd board briefing. Pending any comments from the superintendent or board discussion, I don't have anything further to add at this time.
Nothing from the superintendent, Mr. Chair.
Thank you. Any board members have any comments or questions at this point? Okay. Seeing none, I have none. Next up then will be item 6, 2023-2024 Code of Conduct for Students, briefing first reading.
So good afternoon. Just revisiting our conversation from last time. We're going to start today with an overview of our first briefing. We've also included some items for clarification. We'll provide an opportunity for additional questions and then an opportunity for board discussion and feedback. We appreciate the opportunity to speak to you about the Code of Conduct again. At the last meeting, I was remiss in not sharing that Rachel Gould in the audience has joined us as well. She's not up here today with us, but she was also instrumental in this, so I wanted to thank her for her work on this.
All right, so the last time we saw you for our pre-briefing was May 23rd, where we reviewed our legislative update requirements, our stakeholder input. We talked about the various groups that we communicated with. We used the guiding questions for feedback from all of our stakeholder groups. Areas to include are areas to minimize or delete. So our pictures that took up a whole page, larger sections that could have served as a QR code or a link to our district website, things of that nature we discussed and shared. And our new internet landing page that we are looking forward to as well. Our proposed modifications, rather than having a book for elementary and a book for secondary, we are going to opt into the one single book, but within that one single book, there will be a section for elementary and a section for secondary, and it will be separated out. We also updated 14 of the 26 definitions of CESR, and that was a DOE requirement. We reversed our order of levels to closely align with the Florida DOE CESR reporting levels. So level 5 now is the least serious, where 1 is the most serious. We took all 45 infractions and alphabetized them. And then within the glossary, anything that was not clearly defined within the code in the section in which it pertained to, we expanded on that language, so we were able to eliminate the glossary since it was a repetition.
And then based on our conversation from last time, we added some additional clarification to the school search section. So in our last conversation, Attorney DePoy Bruno discussed the two-prong test. So while we didn't specifically talk about that, what we did was add a statement on that says, using reasonable suspicion, school administrators must believe the search will produce evidence that the student has or is violating the code of conduct for students or the law. The search must be limited to the scope of suspicion. So that meaning the prong of believing that the search will result in what you're looking for and only looking for what you're looking for, so not looking in an area where you wouldn't reasonably find either an item you're looking for. And then for additional clarifications, we went through if there were any minor things that were highlighted. Many of those were very minor throughout, but if you see any highlighted areas, those are the minor edits from our last conversation. And then we also talked about parental notification. So the recommendation was made to somehow get parents more involved in this process. So we were able to work with our technology department, and we will be having a link in the back to school form so parents can access the code right from their forms. They will be able to click that link, look at the code. We'll send out a school messenger which will have links, and that will have a read receipt, and we will be able to tell if the email was open and if the links were clicked in that, and then we'll keep a record of that in our office. So we will have that as a way to make it easier for parents to access the code and also be more engaged in that process of looking at the code as they're signing their back to school forms.
There may be a need in the future to come back to this board and add additional information to the Code of Conduct in regard to athletics. Recent House Bill 225 was passed into law, but we are working to gain a fuller understanding of that. Mr. LaRosa is working with the FHSAA, as well as district staffers collaborating to make sure we have that understanding, because if we do need to bring additions or changes to the Code of Conduct, we will follow the same process that we are undergoing right now for the annual review and approval of the Code of Conduct. If the Code of Conduct does happen to change past the initial approval of it, then the most recent and approved versions will exist on the website for folks to reference. As we start looking into the next school year, we are going to begin our process, this perennial process, in October. We will definitely be working with our existing community groups and partners that we have in the past, but we are looking to expand not only to new members and stakeholders, but also into community for feedback on the Code of Conduct. And one of the guidelines we've received also is that when we do bring things to the board, we'll work to make sure that they are presented not only in the English, but in the Creole and Spanish versions in the draft form.
So looking at our next steps, this is our second briefing. This document will come before the board at the board action meeting on the 27th. From that point, we will continue to work on our translations and then taking those approvals forward for the final formatting. By mid-July, we will have a print-ready version, and by end of July, we will have the ADA compliant version that will be ready for web publishing, and then in the beginning of August, we'll have the printed versions to schools. And that's a small number of printed versions for parents who may need them and ask for them. Most parents will be getting them through the parent portal, through the link, and they can also always access this code on the website. So that's all we have for today, so I'd like to open it to the superintendent.
Members of the board, Mr. Chair, there's no comments from me. The team's done a nice job of presenting the changes of the things that were required in the last meeting. We look forward to any continued discussion and any revisions that might be necessary prior to bringing it to the board.
Thank you. Board member comments, questions? Ms. Jordan.
I'd just like to say thank you for making those changes, because that was really important, and to make sure that, you know, that it is getting into the hands of the parents, and to welcome Mr. Magnan back to the district. So thank you.
Okay. I'd like to thank you all as well. In regards to looking at next year's one, I would just like to put my voice out there again, which you did this year, of just continuing to streamline it. So thank you for your hard work. So we're now moving on to item number 7, policy review briefing, first reading, and whenever you're ready, Attorney Dupree Bruno, if you could go over that.
Thank you, Mr. Chairman. This is the first reading to repeal our current board policies. As you know, we've been working with Neola to do the conversion, and in order to completely adopt Neola's policies, we have to repeal our current policy, and that, of course, has to be done through the rulemaking process. So this is just to repeal the current policies through the first reading.
Board member comments, questions in regards to these policies? Go ahead, Ms. Jordan.
Do we are repealing before we are approving?
It's going together. So you're going to have the first reading to repeal, the first reading of the Neola policies. On the 27th, you'll have the final repeal of the current policies, and then, of course, the adoption. So they're simultaneous.
Okay, only because if there were changes, then that would have to be, okay, thank you.
Anything on the repeal? Okay. Item number 8, which will be the policy review in regards to this briefing, first reading for the adoption of the new policies.
Thank you, Mr. Chairman. The board has been reviewing these policies from Neola since August of last year. They've had pretty much every month since January, very consistently reviewing the different books or chapters in the Neola policies. In May, the board gave a consensus to move forward with the policies after its review, thorough discussion, one-on-one briefings with staff, me answering questions, Neola coming here to review and answer questions, to go ahead and move forward now the policies in their entirety for first reading. This will be the first step in the full adoption of the Neola policies. The second step will be on June 27th when it comes to the board for the second reading.
Comments, questions? Ms. Patrica?
Yes, thank you. Policy 0164.1. Is that even a policy? That's what my notes say. I just want to give you all a second to pull it up so you can.
Could you repeat the number?
0164.1. It's called meeting location and board member participation. I just want to give you all a second to pull it up. Okay, my questions are, what about closed sessions?
Okay, let me just get there, Ms. Patrica, please.
Sure.
0161.
0164.1.
Oh, sorry, 64, okay. So the statute does not, so are you specifically asking about attorney closed sessions or executive sessions? Which
Either one.
Okay.
Because we have decided as a group that we would use the same thing, and I'm not, like, I don't remember talking about it, but in preparation for today, I'm not clear on why it wouldn't be in our policy if we have agreed to do the same thing for attorney-client and executive session as what we're doing for an action meeting. Right.
I'm not sure. So a couple things. One, attorney closed sessions do have a requirement for notice because we have to actually publicly open and close the meeting, but executive sessions do not. So I'm just trying to understand, explain to me a little bit more so I can understand.
So this policy tells us as board members when we need to be physically present and when we don't have to be physically present, right? Is that what this policy does? Let me pull it up myself. I made the notes a little while ago. Board members may participate in school board action meetings and special meetings through an interactive video and/or telephonic system as long as physical quorum of board members is present. Should we add attorney-client and executive session there? Because I believe that the board has agreed that we will allow members to participate telephonically or
Yeah, good
video.
question, Ms. Patrica, because that is exactly what the board did discuss. If you give me an opportunity, I do believe there is a policy that specifically addresses that, so let me see if I can find it. If you want to go to the next question, so, because it's going to take me a little time to try to, but I do believe that we did indicate in one of these policies about the board's ability to participate via telephonic for all of these meetings. I think it's there, but I got to find it.
Okay, thank you. My next question, I think I have 3 in the next section, is policy 9140. Tell me when you all are ready. Paragraph F, under committee meetings, which is page 2 of 4.
Yes.
Thank you. Second or third sentence, it says the chair will meet with a board member assigned as liaison to the committee in advance of each committee meeting. That's not real. That's not what we do, or at least that's not what I do. And I think that might be unnecessarily prohibitive because frequently we meet once, maybe twice a year. And my experience has been that if there's something the board knows is brewing, then we'll say to the chair, please make sure that this item makes it onto an agenda. But we also want to give them as volunteers the opportunity to to decide on their own what they want the agenda to be at several of the meetings. So meeting before every meeting, I don't think is how we do it. So I'd like to suggest a change there. Go ahead.
So I was going to say, there has been some discussion with staff that a lot of times the committees are the ones that are actually creating the agenda.
Right.
So we can change that language if you want. If the board gives me consensus to do that, we can do that. Because I know that's something that staff has discussed. It's a little bit, I think I can read your mind, Ms. Jordan. It's a little different than that question. But this is specifically in terms of board members meeting with the chair of the committee to talk about the agenda. That's your question, right?
That is, for that sentence, that is my question.
So
yes.
we can change it. Remember, this policy, a lot of it was based on your current policy, and that's how it's drafted. But you have the opportunity at this point to change it.
So I'd like to recommend to the board that we we can just eliminate that sentence. Or we could say the chair may meet with the board member.
0174. Thank you. Thank you.
Yeah, Ms. Patrica, yeah, I actually had that question, I think it was about a month ago. I actually went through that. I would be supportive of that, so I don't know if we want to.
Which one?
Of
May, I think
going to May.
Yeah,
Yeah,
like May.
so.
So may
Go.
I ask, excuse me, Tammy, can you jot that down for me? I'm trying to find my track changes and I'm not able to find it, so I just don't want to forget to make that correction. Or if you can make that correction, are you able to, Tammy? Or did they lock it? Looks like they locked it. Oh, let me get out of it. We may not be able to, you know how in the past we've been able to do the track changes? We may not be able to do this because this is active and live and the public can see it. So I just don't want to forget that change though. So Tammy, if you can help me with that. And also the assistant school board attorneys in the audience, if you can help me with that too, please. All right, so we just want to take out that sentence?
I think just changing the will to may
Yeah.
would be sufficient.
Do we have a
I think that's the consensus.
consensus on that?
I just have a question
Go.
because I know that I've asked numerous times on this advisory committee. When we, because it also states that if we are to meet, then we have to advertise it, the board member and the chair of any advisory committee is going to be meeting to even discuss what their roles are. So to me, I think that needs to just be done because we know we're there, we're not part of that committee, we're there as the liaison for the advisory committee. But this puts us as like, we don't vote, we're just there to give feedback, we're there to bring back feedback from them. But now it's put, and that's why I was hoping that the staff liaisons had more input on this too, because this affects what they do as well. And I know that you've been having conversations with them also. But that right there is just scary because if they were to call us, we're just like, I'm sorry, you can't talk to us. You have to stop that conversation. So
I think how we can fix that, Ms. Jordan, is if we clarify that language that says, my recommendation would be that the committee creates its agenda. It can consult, not necessarily on the agenda or creating the agenda, but it can talk to any of the staff liaisons that are assigned to it, and then maybe we'll pull out the board and put that same language that we did for staff liaisons and note that the board is not a member of the advisory committee. That would resolve that one question. We just want to make sure that we're careful that the board member is not part of that decision-making process or having any influence in terms of the direction that the committee is going. So if we clean that language up and say that it's the committee that's going to be creating its own agenda, and then that the board liaison serves in an advisory capacity, like the staff liaison, I think that will rectify that problem, because I have heard from board members that there is a concern with that.
And then not only that, if I may, once we, and as well as the advisory committees, what is the role of the advisory committee? Is it for them to figure out what they want to work on, or is it for us to have them as our advisory committee and say, hey, we really need help in this, and giving it to them, to have something to take on, to come back with ideas that we may need, and that helps us out. So where does that lie at?
So what is supposed to happen is that there's supposed to be some topics provided to the advisory committees for them to work on, and then come back with recommendations to both the board and the superintendent, and then the superintendent comes back to the board and says, here's where we are, what we can do, what we think we are able or not able to do. That's what's supposed to happen. And each advisory committee also has its own mission within the policy in terms of what their parameters are.
Okay, so why don't we do this, then I'll come back to Ms. Patrica to finish up. Why don't we, unless there's objection, ask legal then to go ahead and come up with some language and then come back to us with it? Is
Okay.
that good with everyone?
Is there anything else you want in this particular side from those 2 points?
Go ahead, Ms. Patrica.
Yeah, so we'll be removing the sunshine requirement in terms of board member discussions with chairs, correct? Is that what I heard you say? If I may, through the chair to Attorney DePree-Bruno.
So I'm going to change the language so there's no concern about sunshine, because if I leave it the way it is, my recommendation to the board is that you need to be careful about sunshine violations. Now, if I change it to say that it's the committee that's creating their own agenda, and that the board member is serving in an advisory capacity, and we take some language to ensure that the board member is serving not as a member or part of the committee, then I think I can tweak it so that we avoid it. The concern is that if a board member is participating actively in directing the committee's work, and the fact that the board member is going back and forth and serving as I have to tell you, it's very concerning, specifically with school board advisory committees, which is a little different than what you will encounter in some of the other municipalities, because these school board advisory committees are almost deemed as another arm of the board. So if the board is serving as back and forth liaisons, helping to direct the work of the committee and things of that nature, I get a little concerned in terms of protecting you from sunshine violations. But if you want me to, again, this is the language that you had before. I can tweak it to remove the board member and just make the board member just a liaison that is not a member of the committee and is not directing or setting agendas, et cetera.
I think that's how we function already.
Okay.
So I think that language makes it, I do have 2 more in this policy, and then I'm done, I promise. In the next paragraph of F, so we're still on page 2, I believe. Yes, page 2 of 4. All advisory committee meetings shall or will be conducted with a professional decorum that is supportive of the board's mission to provide a quality education. That is not the board's mission. The board's mission, should we change it to be the actual board's mission to ensure that each child achieves his or her?
Yep.
Or should we change the word mission, because I'm not sure that the board's mission fits in that paragraph. The boards perhaps have it be in line with the board's value of professionalism. That might be more appropriate. I don't know, I'm asking the board. But clearly, that is not our mission, which came into clear focus for me after our strategic planning refresh meetings.
Expectations of professional meetings.
So maybe just all advisory committee meetings will be conducted with a professional decorum, period.
Is that what the board wants? Sounds like that's what the board wants. Okay.
All right, and then my final question, if I may, under District Advisory Council, to sort of get to what Ms. Jordan was just talking about, the purpose of the District Advisory Council has morphed from what we used to do. Here it says the purpose of such information sharing. Wait a minute, let me go back. The purpose of the District Advisory Council shall be to disseminate information concerning the operation of the school district to school staff, students, and parents. That is no longer the purpose of the District Advisory Council. The purpose of the District Advisory Council is to provide actionable feedback to staff and/or recommendations for change to the school board. They do receive information, but it used to be literally what Dr. Hertz said at the microphone today. We used to sit out in that room right there, and they would feed us information, and we would be like, what are you talking about? And then we would go home and share that information with our SACs, but it had no meaning. Now we have district advisory council meetings where staff can walk away. It could be a process issue, like, we need to communicate better, or like he said with the, you guys understand what I'm saying, I don't need to keep talking. So could we change the purpose to include dissemination of information and the provision of actionable feedback for the staff and/or the school board?
So if,
I was just say, in essence, that's what they're doing, so yes, let's change it. I mean, and I think that's well worded.
so we're going to add actionable feedback to that one, so to receive information as well as take actionable feedback. Now, there's one thing I do want to double check, because SAC is a creature of statute.
Correct.
And that DAC obviously is made up of SAC, so I want to just double check the statute to make sure we have that language, correct. And then I don't see any other statutory prohibitions in terms of actionable feedback.
Okay, so the language that I have written, and I can email this to you, is their purpose is to receive information and provide actionable feedback to improve the experience of our stakeholders in our schools, on our buses, and at the district. So I can copy that and send that to you.
Thank you.
I think those are my only comments. Just let me confirm. It is. Thank you for your...
And then let me look at the one that you were asking about in terms of the executive sessions and the closed sessions. Oops, I just got out of Board Docs, so hold on one second, please.
Yeah. Board members are going to direct you to policy. I apologize real quick. I just want to make sure I scroll down. We'll direct you to policy 0166. It's referred to as exempt meetings. And I believe the passage that Mr. Pri-Bruno, while answering questions and responding to all of you, was also looking for at the same time, is at the very bottom of page 1 with it says any other meetings permitted to be exempt under Florida law, and it speaks to the exception of attorneys, sage senators, board members, and how board members may participate. I offer that as a place to begin to read, the very bottom of the page before you see Neola 2021.
Thank you. And I just sent that email with no hello or goodbye or anything, just the language. Please don't think that was rude.
So thank you, Dr. Bernier. 0166, and that is the language that's very specific with regards to the ability to use a video or a telephone system to participate in executive sessions. The only reason shade sessions, attorney closed sessions are not included is because of our notice requirement, and it's very, very specific per statute that we have to list who's going to be present. So if somebody calls out sick, they won't be able to just participate by Zoom if we don't properly notice it, if there's an emergency. So that's why that is not there. So attorney closed sessions, we would like for all the board members to be present. But cybersecurity sessions, bargaining session, anything else that is an executive session that's covered, you can participate electronically.
Could you repeat the part about the shade session? Is it statute that prevents us from?
So the issue with both of them, both the executive session and the attorney closed sessions, is if you're participating by Zoom, we don't know who's in the room with you. Right. And so there may be somebody that's there and that there's a concern. So there was some latitude with regards to executive sessions. They don't have to be noticed, and the statute's pretty clear. But the attorney closed sessions have additional requirements where we're actually noticing physically who is going to be present. Plus, you see me when we have our attorney closed sessions, I put it on the record who's there. So if somebody's participating by phone or video, I don't want to go on the record and say these are the only people that are there, because we may have people that, are in the room. And then second of all, again, because of the notice requirement, if we are noticing that these people will be there at the meeting, and somebody says, I'm not available to come, or can I call in sick? I have not noticed that as the person will be participating by Zoom, et cetera. Those things have to go out timely, and that's what my concern is. Does that make sense?
Yeah, but, I mean, if I couldn't come tonight because I'm sick, we haven't noticed that I'm going to be on the phone tonight.
That's different because it's a public meeting. So it doesn't matter if you have somebody with you while you're driving up somewhere or if in your house, because these are open notice public
No,
meetings.
I understand that, but I'm trying to digest the public notice part. You indicated that public notice was important to say that who was going to be there and who wasn't going to be there. The same is true for an action meeting. Public notice is important, right? We've given public notice. The way I attend, I'm not clear how that impacts public notice.
Two different things, because the public notice in the attorney-client session is very specific as to who can attend. The statute's very, very clear, and there's attorney general opinions on that. And that has to be put in the newspaper to say, here's who's going to be there. The statute also requires us to do the opening and for the board to say who's going to be there. And then you see when we have our sessions, I actually put on the record who's going to be there. Because once that case is done, somebody may want to see the transcript or something like that. Whereas these meetings, they're open to the public. The board has already designated in its policy how you're going to handle if somebody's out. I think a lot of districts do it the same way. So anybody can attend. You can have somebody in your car. It doesn't matter because it's open to the public. I don't know if I'm answering your question.
No, no, I don't think you are, because attendance doesn't have to be physical, right? So I thought the board had agreed that the shade sessions and the executive sessions, we were permitted. My concern is this. My concern is we've been through a pandemic where we're encouraging people if they, like I used to go to work with the flu. I would never go to the work with the flu now. Physically, I would never go to work with the flu, but I will work through the flu. And if I'm home with the flu and I'm capable of participating in a meeting, I don't think I should be excluded because I have an illness that other people can catch. I'm being respectful to you by not coming and sitting at this dais, but I shouldn't be excluded from the work just because I'm sick. I get the piece about, there could be other people in the room. We are adults and we have to behave ethically. And if you ask me, is there anyone else in the room? And I say no, I mean, you can ask me to scan the room with a camera if you want, you want to make that part of the policy. But I don't know. It feels weird to exclude board members because they're doing the right thing for the people around them.
I think it's just because of the nature of the attorney-client shade sessions and how very restrictive it is in terms of who can participate. I mean, all of them are the same, but this one really has additional legal parameters in there. But if the board wants me to change that, I will change that. I will say that when we're having those attorney-client sessions, don't think I'm cross-examining you, because I will ask questions in terms of where are you, what are you doing, why are you out, what's the excuse, and who's with you, etc. I have to put that on the record.
That makes sense. I don't like to be excluded.
Real quick, I know Ms. Jordan wanted to go ahead on this topic.
Well, thank you. I just had a question back on the 9140, because I really appreciate the fact that purpose is definitely something that for the advisory committee, they have to have a purpose or there's no sense in even having them. But also, in saying that, there are 6 meetings, essentially 6 meetings. For us to say you're allowed to miss 3 meetings and then work does not get done, I think I think we should decrease the amount from at least 2 meetings versus missing 3 meetings, which is half the meetings. And change that number, because that way we can try to find people to fill that seat that really want to be there. Because I know when I speak to the people, I always tell them, you have 6 meetings before they even sign up for it. And I make sure they understand what they're signing up for, and the work that is they're responsible for. So that's what I would just ask about, what you all think about changing that 3, allowing people to miss half versus 2 meetings. Thank you.
Okay, Mr. Persons.
I believe some of the committees don't even meet 6 times. Maybe we don't want them to, but if they don't meet 6 times, and they could miss, they may only meet 3 times. So percentage-wise, we're having such a hard time filling the committees, which is a whole nother discussion of why that is, which I believe is being on film and everything else like that. I'm not sure a number, you know, if you say 3 is 50%, I mean, because some, I mean, have talked about meeting more than 6 times. Okay, I don't think do we have a statutory they only can meet 6 times? I mean.
So the policy requires them to meet from September through April, so 7 months. However, there are some committees that continue to meet on their own volition during the summertime. But it's not a statutory requirement. This is your board policy.
So I'm not sure how to come up with the number. If they all met, I agree with they all met exactly 6 times, then maybe we could come up with a different number. But if they were only meeting 3 times for some reason, because of a pandemic or something, and we have on there, you can miss whatever, it could be tough.
Go ahead, Ms. Jordan, then
Thank
Ms.
you.
Patrica after that.
And the reason I bring that up too, because if in fact someone has missed 3 meetings, and you can see finance is one of those, so they have not been able to do any work for, 3 months. However, if you miss 2, that gives us the ability to go out and try to replace that person so they can do the work that we're asking them to do, and the reason that they're there. That is the only reason that I'm bringing it up. It unties our hands, and it allows us to bring other people in, or even go out and look for those people that we could possibly bring into that seat. And that's all I'm going to say about it. Thank you so much.
Go ahead, Ms.
So
Patrica.
I agree, 2 meetings. I think that's appropriate. The other thing, to your point, and to the point that was made during our board discussion that I was absent on the phone kind of for, committee meetings, A, page 1 going on to page 2, it says all committee meetings shall be videotaped. I recommend that we remove that from policy. Because I do think I think one of the reasons why we're seeing such low participation in finance in particular is because they don't want to be on videotape discussing some controversial issues and have it be used against them when it's cut and pasted and thrown on social media. So I recommend we remove that sentence altogether. And then each committee can decide at the beginning of each year whether they want to be videotaped or not.
Mr. Persons.
I just want to make a comment. The fact that it's not videotaped doesn't mean it's not open to the public.
Correct.
The public is always able to attend the meetings. I just want to make a clarification there.
Okay. First off, let's just go back to the number of meetings we talked before we go on to the next part. We're talking about 2. Are we on board with that, or do we want to come back on that, or what's the consensus up here? 2?
Yeah.
2?
I can go along with it.
So that would be under membership, section D. We're going to try remove 3 and put 2, so we'll read members who miss 2 meetings of the committee during the school year shall be removed from membership.
Now, going back to Ms. Patrica's second comment, I just wanted to make sure we're keeping everything in order. So, in regards to videotaping, where is that directly again, under which comment?
Committee meetings, paragraph A. It's the 3rd sentence. All committee meetings shall be videotaped.
What would be your proposed amendment to the language?
Remove the sentence, and then the staff liaison at the beginning of each meeting, or perhaps the board attorney at the beginning of each year, can advise the committee, it's up to you whether you want these videotaped and placed on YouTube or not, and then you put it to a vote of the committee, and that's how they conduct themselves each year.
Go ahead, Ms. Jordan.
I think originally, it was just recorded. So that way, if anybody wanted to go back, they could listen to what was said. It became an issue when all of a sudden now I'm on camera that's when I think we started losing people, from what I noticed. Because people they really don't want to have their faces up there where you know who they are, and you have the ability to go after them. Listening to them gives you the same ability to hear what is taking place in the meeting, even though they are open to the public. Anyone can, of course, come into those meetings because they are open. But I think that was the issue, was the actual videoing of the meetings.
Okay, Board, Ms. Langford Fleming.
I'm in favor of removing just that statement. I like the idea of each committee being able to decide at the beginning of the year. I mean, we have, like Chairperson said, all the committees meetings are open to the public, and there are minutes taken at the meeting. So if you want to go back and review what was being said at the meeting, isn't there a way to post the minutes so that way they can go back and just review what was discussed and kind of catch themselves up? I just don't see why it needs to be videoed or recorded. I mean, these are volunteers that are giving their time, and we're having a hard enough time as it is. So those are just some of my thoughts about the videotaping and the recording.
Ms. Giovanelli? Ms.
Well, the reason it was actually voted in to begin with, it was for public transparency for the public, and then the ability to see what's going on in the committees and have a better understanding, and if they have the time to participate. Even you, Ms. Patrica, just said how valuable it was to watch the curriculum advisory meetings and what happens in those meetings, and I found value in it. I also found value in EDAC as well, because it allows the community to see what's going on and what the work of the district is, you know, the works of the district and the works of the committees. Finance is the only one that has not been able to meet the quorum, and that seems to be an issue within finance. So, you know, I'm not opposed to the idea of them deciding, but I found value in going back and watching construction advisory. I found value in going back and looking at the curriculum and watching the public speak, because it was important for others to hear their voices at curriculum advisory. And I think that's what's important, is the community having the ability to voice their opinion and advocate for what they feel is what's needed at a school district and what's our kids are receiving, the information they're receiving. So I'm having a hard time with that one. Thank you.
I'm along the lines of Ms. Giovanelli and her comments. I would be on board with still keeping it, but I'm open to other suggestions. Board, Ms. Patrica?
I would say that when this was adopted by the board, we could not have anticipated that it would be weaponized and used against volunteers. And that's the problem. We are elected officials. We put ourselves out there to be chided and insulted and sworn at and treated very, very badly. Our volunteers should not be subjected to that. And our volunteers are subjected to that when people go in and they cut a YouTube video of an advisory committee meeting and they take it out of context and put them out on social media out of context. And that's, I seek to protect our volunteers in that regard. Is it valuable? Yes. But does the chilling effect on participation by volunteers outweigh the value? In my opinion, yes, it does. So that's why I'd like to see the sentence removed.
Okay, why don't we go
Mr. Chair,
on?
I have one more.
Mr. Parsons, go ahead.
Even if we're not videoing, as you said, they used to do, just record it. I think that's a nice option there, to just be able to have the recordings accessible at a minimum. You know, maybe all meetings will be recorded, or if voted on by the committee, videotaped or whatever, something along those lines. So we're giving it a little more transparency, but also protecting, you know, the volunteers.
Okay, I would be.
I don't know, I'm just a thought.
I would be on board with that, at least having recording. Are we referring to, let's be specific, audio or video recording?
It would be an audio recording. I mean, minutes are nice, but they're not specific enough.
Correct.
So I think you need to go another step. And
I would be on board with going to the audio recording. I think that would probably be the best compromise at the moment. Can I hear my fellow board members on that?
I would completely agree. Thank you, Mr. Persons, for making that recommendation. I think the audio is sufficient. It allows someone to go back and listen. We don't need to be watching and looking at someone. I think that might make them even more comfortable in speaking up without having to be on TV. So, thank you.
Thank you for Ms. Jordan for that suggestion. Are we good going to audio recording only at the moment for these meetings? Okay, Attorney Dupree Bruno.
So we will remove under Committee Meetings A, where it says all committee meetings shall be videotaped, and it will now say all committee meetings shall be audio recorded.
Thank you. Okay, do we have any other comments and questions in regards to any of the new policies at this moment?
I do need clarification from the board, going back to Ms. Patrica's, I think, 0166. Do you want to add attorney closed sessions to the list of those that board members can participate via phone or videotape?
Mr. Person.
I'm sorry, not videotape, video conference.
I don't have a problem with that, but for the record, you're going to have to be asked if you're alone, and then it's up to you type thing. So don't be offended, but I think would be a nice compromise on that one also, just to realize will be the process of it.
Ms. Jordan?
And I believe we already had this conversation. I can't remember when we had the conversation that we would allow this to take place, except for security.
Except for shade sessions, not all the executive sessions are already there.
The security ones, we're not going to do. Anything that dealt with security, we could not do that.
So now that you raised that, Ms. Jordan, I need to make sure I have clear direction from the board, because cybersecurity sessions are different than safety and security sessions, and executive sessions for cybersecurity require a court reporter to be present. Executive sessions for safety and security do not, and nor do any of the other executive session meetings such as bargaining, usually safety and security and bargaining, they're the main ones. Now, attorney closed sessions are the ones that's very, very unique and specific to the statute, and is actually in a whole another section of the statute, and that also requires a court reporter to be present. So I want clear direction as to what the board would like me to do.
Mr. Persons?
I would think cybersecurity still needs to be in person only. I think that's the one that we just can't, because if they're good enough to be able to hack our computers, they can hack our phone systems, as we call it. I mean, I hate to say something like that, but that's of like the utmost importance. But I think all the others, we should be able to phone in. I don't see a problem there and participate, as long as we go on record that we are alone. But that's my thoughts. If anyone else has any, I'm flexible.
For me, I'd personally like to perhaps explore a little bit further, and maybe this can come up in our one-on-ones first. I have a couple questions in regards to policies and statutes for regards to that. And when you say phone in, phoning in, Zoom?
Well, not phone.
Well, no, that's, I'm
I know, I
curious,
understand.
the method of, in regards to this. What does the rest of the board think?
I'm with you. Brother?
Yeah, spend a little more time.
Yeah, okay. So let's, if you could look into some of that and maybe go over it in some of our one-on-ones, then Ms. Dupree Bruno.
So 0166, we will discuss further in another one-on-one to discuss all of the executive sessions, attorney sessions, and what the statute specifically says.
Correct. Okay. Any other clarifications from anything that's previously been said? Ms. DePree-Bruno?
No, Mr. Chairman.
Okay. Comments, questions, policies? Mr. Persons?
Yeah, just want to say that these policies are our framework. The process documents and everything else is still being worked on as we speak, to make how this all works together. But you got to have the policies first in order to create the process that goes with it. So I just wanted the public to sort of know that. I don't have any problem with these policies, except for what small things we're doing.
Okay. Anyone else? Ms. Jordan?
Thank you. On policy 2522, I just wanted to ask about that one, please. As regard to where it says, oh my goodness, where is that at? How do we know, or how do they know in the challenge if a book has been read in its entirety? How do we, and that's to Mr. DePree-Bruno, if I may.
You're referring to the person who's objecting?
Right. So, right. The questions on that is, have you read it? Have you read everything in its entirety? And how do you know if they actually have? And also, if the form is not filled out completely, does now the staff have to, they send that back because they're not going to work on it unless it's filled out completely as asked, correct?
So I know that in July, because I don't want to step over what staff's going to present. In July, there's going to be a full discussion in terms of everything that deals with books. What I can tell you is that when you're filling out the form, the school district is hoping that you're being honest and filling it out with appropriately, and that you're putting all of the information in there that needs to be put in there. So hopefully the individual has read the book. That's one of the things that we ask, have you looked at the totality of the book? As well as for the appeal form, it says the same thing. So that's the only thing I can say. Now, I will say that the Department of Education has been instructed through House Bill 1069 to create a form. We do not have that, or the State Board has been directed to create a form. We do not have that form yet, so I will not be able to advise as to what's going to be on that form and whether or not there will still be a requirement that you read the entire book, because we don't have the form yet.
And then then the other question, when it comes to...
Excuse me, Ms. Jordan, it looks like we're having some technical difficulties with board docs. I'm having some problems. I've completely lost board docs.
You just need to log back in.
Log back in?
Click on it and it will work. The same thing happened to me.
Thank you. I'm sorry, Ms. Jordan.
Okay, and then the form, if it is not completed as required, it gets sent back to the individual. We're not going to...
Mr. Chair, there was an expectation from the superintendent after I first came on board regarding a particular challenge where I believe staff was trying to accommodate the request. We made sure at that point, through your direction, through the superintendent to staff, the expectation was that each book has to be individually challenged, and those processes and forms that are associated with that must be filled out completely.
Thank you.
In the cases, if they're challenged for a reason and the reason isn't appropriate in the book, then we would send it back to them and say, you might want to think about, there is no pornography in the book. There is, however, you may want to challenge it under a different category. So we will make sure that we follow the policies and we will procedures that align to that particular policy. In fact, staff is already doing that now, and to Kathy DePree-Bruno's point, we are doing work sessions in July to make sure that we're covering this material and giving the community additional input and providing opportunities for the community to continue to address this matter.
No, thank you, I appreciate that, but I know right now we're working on policies before the July meeting, so thank you for that.
And the only other thing that, if I may, Mr. Chairman,
Proceed.
add is that even though we have, because we've done this whole NEOLA process, we also have new laws that are coming into play July 1. Some of those new laws were incorporated already in these new policies. However, I will tell you, there's going to be new policies that will be coming forward or updates to policies. And we're planning on bringing all of those to the board by August. So we have all of the legislative changes. So I just wanted the board to be aware and the public also to be aware of that.
Thank you. Any other comments or questions at this point? Ms. Juvenelli?
Regarding making sure that someone that's challenging the book has read the book by its entirety, I think we have to be cautious, because if I know as a parent, if I started reading a book that has some vulgar information in it that I don't personally want to put in my head, I may not continue to read that book. However, I'm going to bring it to the attention of the school, and I would probably have never taken it to the challenging. I would probably gone to the actual principal, or the teacher in the classroom that suggested that book, if that's the way it went. But I think we have to be careful on our expectations of what we expect from someone. If they feel that the book is inappropriate for a child at a certain age, and I think that they have that right to do so. And I think that we're going to have laws that support that. So I think we just need to be careful. And it's the same route that if it doesn't pass, when it's challenged and it's not felt that it should be pulled and removed from the shelf, that we respect the process. So I think we just be careful about how we're going to make someone do something. I think making someone do something and making sure that they did that, and we're talking adults here, and if they said they read enough that they don't want to read anymore, and they challenged it, that should be sufficient, my opinion. Thank you.
Just for reference, I'm still having issues with board docs right now. I don't know if
I am
anyone else
too.
is, so.
I'll wait this
Go ahead.
So I hear you, Ms. Giovanelli. However, the process or the steps through which the committee will look at the book is in its entirety.
Yeah, the
So
committee does.
it would be important for the person challenging the book to have read it in its entirety, because any phrase taken out of context without looking at the entirety of a work could be considered offensive. So we could be wasting staff's time if we're not requiring, if the end result is going to be looking at it in its entirety, then I think it makes sense for the challenger to have also looked at it in its entirety.
Is that it, Ms. Patrica?
That's it.
Mr. Persons?
I think the forum has very specific things you can put on it. And the only disadvantage of the challenger not reading it through its entirety, it won't change any of the thing they're objecting to. All it will do is maybe have a lot more things to back up their claim that it should be removed or flagged or whatever. I don't think it needs to. I think the committee, to make their declaration of the book, their synopsis of it, needs to read it in its entirety, but not necessarily the challenger. The challenger just needs to have enough on their form there to bring it before the committee. I mean, I don't think anyone's going to bring one sentence and say, I'm challenging this book.
I'm not going to.
But maybe I'm wrong.
Okay. Anything else? Anyone? Comments, questions?
Mr. Chair, I just want to clarify one thing too. As we're going through this process and reviewing, and we'll be updating policies further, we have to remember that House Bill 1069 goes a little bit more deeper in terms of the definitions as to what the school district has to remove, which does impact whether or not somebody has to completely read, et cetera, because we may not be applying the Miller test to all situations. Some, yes, definitely, but some not, because of the new language in HB 1069.
Thank you. Anybody else? Okay. Appreciate everyone's hard work on that for the public. It's been a long process, it's been an interesting process, and we're going to continue working on it. Next up will be item C, public comment. Attorney Dupree Bruno, if you can address public comment, please.
Mr. Chair, just clearly, we do not have an internet connectivity problem. It appears we have a board docs issue. So, I just Googled dogs and I got all sorts of little fuzzy pictures. So Mr. Alton is currently in contact with with the Diligent brand, trying to make some determinations on board docs and what's transpiring with their program.
Thank you, Mr. Superintendent.
Thank you. Before we start with public comment, I just want to thank the board for the work that went through to get these Neola policies done, because I know that there was a lot of reading and there was a lot of questions and examinations. So I'm glad that we're moving forward to the second reading. Mr. Chairman, if you could please just find out from the board, with the exception of 9140 and 0166, that the remaining policies can move forward to the second reading.
Okay. Is there any objection to moving forward on the remaining policies we haven't discussed? No objection.
And then with regards to 9140, I think the corrections were very clear, so we will make those corrections with the track changes. May we move that with those changes to second reading?
Any objection to moving forward? No objection.
And then 0166, that depends on what the changes are, so I think I'll bring that back to the board so the board can review that.
Yeah, that was one
Okay.
we'd like to follow up on 101s, please.
Thank you.
Thank you. Is that it?
That's it. Thank you.
Thank you.
Want me to move forward to public comment?
Please proceed.
Thank you very much. School board policy provides the opportunity at this point in the meeting to address the board concerning any matter on this meeting's agenda. If you completed a public comment card, please provide it to the basket in the back of the room or to staff, and public comment will be held at the podium in the center aisle and in the front. Please be advised that the board will not respond during public comment to remarks made by speakers. Speakers who fail to follow proper decorum in the chambers will be ruled out of order. Any speaker continuing with such remarks will be required to relinquish the microphone per Board Policy 1.11 and may be removed from the chambers. There will be one warning. Per Board Policy 1.11, the time per speaker is 3 minutes. You will find a countdown on the big screens in the front of the room. Once your time has elapsed, the microphone will automatically shut off. Please state your name when you approach the microphone. There is one change based on the board's discussion that they would like to have any responses from the superintendent if he is able to respond to any public comment. So I wanted to make sure that the public was aware of that as well. At this time, Mr. Chairman, there are 6 speakers that would like to address the board.
Thank you. Is there anyone else in the audience that has not signed up for public comment that wishes to make said comment? Okay. Just to be aware, for briefing meeting, public comment shall be on the topics that were addressed in the briefing meeting. Any general school board comments shall be addressed at the action meeting tonight. Whenever you're ready, please proceed with the names. Attorney Dupree Bruno.
Thank you, Mr. Chairman. Will the following individuals please line up? Marge Cox, Bobby D'Alessandro, Robert Roper, Sharon McGill, Madeline Stewart, Tara Jenner.
Thank you so much for the opportunity to share ideas with you this afternoon. My name is Marge Cox. I'm a retired library media specialist. I spent 40 years in the public school system and treasure the time I spent there.
Ms. Cox,
I treasure what you're doing on behalf of students as well.
Ms. Cox, if you could just give me 1 second, because we're having some technical difficulties, the timer's not on the screen.
Oh,
so
I'm
I'm going to
sorry.
go ahead and time it with my phone. So if you give me 1 second and I'll set that up. Okay, Ms. Cox.
Okay. Sorry, I didn't realize I needed to wait. I'm Marge Cox. I'm a former public educator for 40 years. I loved my time in my job. I appreciate so much what you're doing on behalf of children in Lee County. I live in Bonita Springs. I come today to support your library media specialists and teachers who have classroom libraries, because I think that's critically important for students, and I have research that will support that it's not just my idea, but that it is several professional organizations that believe students need to have access to books. One is from the United States Department of Education, research that showed access to reading materials was critically important for students. I am not going to read it to you, but I have sent it to you so that you can read it as you have time. Another one was from the Educational and Career News. Access to books is critical to ending illiteracy. There's also one from the International Reading Association, providing books and other print materials for classroom and school libraries, a position statement of the International Reading Association. One from the American Library Association, empowered by reading. The benefits of giving youth access to a wide variety of reading materials. And last but not least, from Scholastic Publishing, Kids and Family Reading Report, the reading's impact on kids' mental health. All of those organizations believe that it's important for students to have access to a wide variety of books, and I commend what you're trying to do to work within what the state has expected of you for getting books into kids' hands, and I appreciate what you're trying to do to make it so that they will have access to books. Thank you for your time this afternoon.
Okay, Ms. D'Alessandro.
Good afternoon, Attorney Bruno, Dr. Bernier, and board. My name is Bobby D'Alessandro. I'm a resident here in Fort Myers and a very interested citizen, former superintendent here in Cambridge, Mass. I'm here to speak today about the policy 2522 and the processes that are being developed to implement that. I first want to comment about your staff under the leadership of Jeff Spiro. They have had to listen to many voices and many opinions about this procedure. And I have to say, I have in our Purple group, which is just a group of people that care deeply about children as you do, they've listened to us, they've given us access, the Curriculum Advisor Committee, so I can't thank them enough. And they have really diligently tried to adhere to the statute. Now, we have read and know that any county can develop their processes the way they want to. And we have read many of these policies throughout Florida, and there's a variance, let me tell you. But I may be prejudiced a bit, but I think Lee County's policy is fair and just and one of the best I've read, and I've tried to read them all. We strongly believe that Lee County has to have a sound educational process done by educators with input from the community. We also believe in parental rights, absolutely. But it's amazing to me that most of the book challenges don't come from parents, but they come from community members, which is part of the statute, I understand. One situation that I want to bring forward to you that you might have heard of or not, but you know, as the book is challenged, you have to go through a process of going through the committee. If you don't like that decision, go to the board. If you don't like that decision, go to the state. Now, if that state still overturns that and says it goes back to the library, this group would like to have that book flagged forever as a challenge book. Now, that seems to be an outrageous situation and very manipulative. So if this comes before, I'd like you to think about it and consider it. And all I'm asking you is just make a good decision for the kids, as you always do. Thank you very much for your attention. Have a good evening. I'll be here.
Good afternoon, everybody. I have to applaud you all for your stamina. It's amazing. Hours of very good discussion. I'm Madeline Stewart, and I appreciate the opportunity to talk with all of you today. First of all, I want to thank you, the administration, the staff, Attorney Bruno, and particularly Dr. Spiro and his curriculum coordinators, who are thoughtful professionals who have done a wonderful job, I believe, in crafting this policy. And I also want to thank you, the board, for supporting them to do this work, because it's going to have far-reaching effects on the education of students in Lee County. What you do here and what we do with children in our schools has a huge impact on the future of all of us. The policy, as everyone has said, adheres to the law as it should, and importantly, I believe it provides a solid framework for the book challenge process that the staff will be crafting. I want to read one particular sentence in the policy. No challenged material may be removed solely because it presents ideas that may be unpopular or offensive to some. I think that is a very important statement, and I applaud its inclusion in your policy. All of us are joined in this community, all of us, even if we don't agree on everything, in the goal of providing an education for students that will prepare them to participate actively in our democracy and live fulfilled, positive lives. We are a pluralistic nation. We live in an interconnected world. For each of us, at any age, books of all kinds provide inspiration, new ideas, new ways of seeing and learning about ourselves and others. And they provide us aspiration for a better world. I'd like to end with a quote from John Dewey. He said, "All true learning begins when our comfortable ideas turn out to be inadequate." So I ask you to consider that, and I thank you so much for your time.
Good afternoon. My name is Sharon McGill. Oh, I'm sorry.
You're good.
My name is Sharon McGill, and I'd first like to thank the board and everyone else in the district who was involved in working on these policies. It was no small task, and that is acknowledged and appreciated. To try to develop the policies for the district that still have to be in alignment with the state statutes is a major task, because those policies not only affect every child in the district, they affect every employee in the district in some way, shape, or form. So thank you again for all of your efforts and your continued efforts. I would like to address, first of all, Policy 9140, the Citizens Advisory Committees. Some of the questions that were brought up by the board were ones I had written down. Number one being changing the number of missed meetings from 3 to 2. If you look at the 7 meetings that most of the committees have, 3 meetings missed is 40% of the meetings. I mean, I think that's not a reasonable expectation from anybody. And when you sign up for a committee, you need to understand that and accept those responsibilities. So I appreciated the fact that it was being considered to be moved from 3 to 2. The other thing was the terms for committee meetings, for committee members. Board members have term limits. Superintendents have term limits. Why shouldn't the committee members have term limits? What you want to do with committees is reach out to as many people in the public as you can, to get as diverse opinions as you can, to try to come to some consensus that's in the best interest of all students. And by allowing the same person to stay on a committee term after term after term after term does not do that. You get the same opinions over and over again. So I would like you to consider some kind of term limits on committee members. And the other thing is that Committee members may only serve on one committee and/or district advisory council at a time. So if somebody's on DAC, they shouldn't be allowed to sit on another district advisory committee. Or if they're on a district advisory committee, if they're on a board advisory committee, they shouldn't at the same time be able to sit on DAC. Again, you're trying to reach as many different people as you can and get all the diverse ideas that you can. And, you know, just allow them, if they're inadvertently assigned to accept the one they would prefer to stay on. Do they want to stay on DAC, or would they rather stay on the...
Thank you, Ms. McGill. That's your time.
Thank you.
Okay, Pastor Roper.
All right, Robert Roper, sporting some new colors today because amazingly enough, we have a lot in common, and it's not just the color of our shirts. On the core issues, we could agree on a lot of things. We should actually get together and meet sometime. I think it'd be good. Concerning the way the challenge policy is written right now, there's very few elements of the policy that I would disagree with. I think it's well written. I think it's well thought out. It complies with the law. What I do disagree with is the order in which you put the solution at the very end, where it's labor intensive for the entire board, for the ad hoc committee, for the person making the challenge, for the public attending these public hearings, instead of putting the solution at the beginning and avoiding all that. It's possible to do, and I really think we should take a step back and look at it. The way the policy is written today, my understanding of it and the process documents, it's a train wreck getting ready to happen. Please consider a fresh look at putting the solution at the beginning as opposed to the end. If I have any time left, I want to talk about the fact that we just repealed 205 policies and added 586. It's like taking a drink of water out of a fire hose.
1 minute and 32 seconds.
Thank you very much. So one of the things that I noticed is missing right away is red strike-throughs with red lettering that denotes changes. Now it's shadowed and highlighted, and it's really hard to figure out what's what. I missed the line numbering that used to be there. But the biggest thing is that the process documents are not linked in the policies. And that is huge, because the devil is in the details. It's okay to have the framework, and I get it. And I get why you're doing so many at one time. I'm not even objecting to that. I know it's got to be done. It would take you forever. You guys would all retire before it got done if you did it at the regular rate. But the way we're missing the process documents linked into the policies just leaves it for anybody to come up with a way to comply with the policy without public oversight or input. And I think we're missing something very important there. Thank you.
Tara Jenner, what he just said. Today, you had code of conduct, over 200 policies considered for repeal, and almost 600 policies proposed for adoption. The better part of the past few days have been scrutinizing these documents and had difficulty also being able to compare them because they weren't side to side. I'm not sure how advisable it is to jam so much into one meeting, but it is what it is. I would personally like to see an archive system for previous documents so that you can see where we've processed and changed things from the past to the present, or at least from the present to the future, so that we don't end up washing, rinsing, repeating, and making the same mistakes that you've theoretically fixed this time around. But since there's so much on the agenda, I'm going to focus only on one policy, and you guys probably know that's my favorite policy, Board Policy 1.11. The new policy is not making a whole lot of changes, except possibly, if anything, it's more restrictive when it comes to public policy. It's sad that many of the board campaigned for more transparency and interaction with the community. I don't see where that's translated to a change in this policy. Let me address a few points to consider. There's 1 hour for public comment, and still there's an arbitrary 3-minute, 2-minute, and 1-minute time cutoff based on the number of people that sign up to speak. Why not cap the comments to 3 minutes and then take the 60 minutes and divide it by the number of members of the community that want to speak? So for example, if there's 24 speakers, they'd get 2.5 minutes rather than 2 minutes. We'd have calculators, and we have a countdown clock usually, so it wouldn't take rocket scientists to do that. Speakers take time to walk from the back of the room to the front of the room, so why not allow clapping during the transition time? It won't delay or disrupt anything, but will most certainly give you additional feedback from those in attendance, especially those who maybe choose not to speak or are limited because of the number of speakers allocated. Also, why disallow placards as long as they don't impede ingress and egress or interfere with anyone's view of the board and speakers? How would this not be beneficial to give you some nonverbal communication on how people feel about topics being presented, unless, of course, you're afraid of paper cuts. As for the specific language added to preclude public comment prior to the election of the board chair and the vice chair, I encourage you to consider holding off for that right now for obvious reasons. I will be delving into other policy proposals in more depth and reach out to some of you via email if anything draws my attention that I feel really needs to be addressed in detail. The definition of insanity is doing the same thing over and over again and expecting the same results. When my employees come to me with a reasonable proposal that's different from what I originally envisioned, I'll always try to hear them out and look for a way to say yes when possible. If they totally disregard me as an employer, that I see as a problem. This approach should be applied even more when it's the community reaching out to the...
Thank you, Ms. Jenner. Mr. Chairman, that concludes public comment.
Thank you. Mr. Superintendent, do you wish to make any comment at this moment?
My comments will be brief, but I think they're worth addressing, and I thank this community for the opportunity to put this in place. There will be opportunities where I'll have very specific answers based upon very specific problems. There'll be other opportunities where we will have to follow up. There'll be other opportunities for those of you who have not noticed, that is, people have particular personal issues with students and educators. I'm very proud of the staff gathered in the room who then meets those families outside the chamber and begins the work immediately at a board meeting. So I don't think everybody who watches a board meeting or a briefing gets an opportunity to say that. Specifically to Ms. Jenner, we will certainly look into all of your recommendations. Appreciate your focus in making sure that the public has that opportunity to comment. For my individuals who are trying to get closer together in terms of the color that they're wearing, I appreciate that sentiment, and I appreciate the aspect of what I do believe is you have much more in common than you have differences. I have read some of the articles that were sent earlier today and have forwarded those on to staff to help inform their decision as we continue to develop the procedures related to this policy. Books are important to children. Reading is definitely the skill that all people need in order to be successful adults. I don't believe, no matter what the diversity in the room includes, that anyone precludes the fact that reading is important and children need to have access to good quality text and materials. And I think that's our place to start. The question becomes, how do you comply with the law, and how do you leave opportunity for parents to exercise their right and, what I believe, is a parent's responsibility. So we will continue to use the information provided here today to continue to inform us as to how we will continue to develop the procedures, because Pastor Roper is correct. Procedures are the backbone of a policy. The board knows that, and we will begin that work. It's already underway. But we will continue to use public input through our committees and the other discussions we had today very specifically around some of the board advisory committees. It is important for the public to participate, and I will tell you on this particular issue, we've had great participation. I will also echo the sentiments of a board member who was unable to get to those specific meetings, but I did watch them. I will tell everyone in this particular room who's represented behave with amazing decorum, and I credit the staff for putting together a great input process that will inform our procedures moving forward. Thank you, Mr. Chair.
Thank you, Mr. Superintendent. Thank you, everyone, for your comments today. They are appreciated. At this point, we're going to move on to item D and E, go to the order and board comment. I think we will start on the far end. Ms. Morgan, if that's all right.
I have none, and I shared my comments with you in writing, so thank you.
Ms. Langford Fleming.
I have none. I'll wait till this evening. Thank you.
Mr. Persons.
I just want to say books are important. One of the things we're doing is every elementary teacher throughout the whole district is getting 250 new books this year through the state, and to add to their in-class library. So, I mean, that's a good start right there.
Ms. Jordan?
I don't have anything at this moment.
Ms. Patrica?
So I'm going to give almost my entire full board report now, so you don't have to stay here and listen to it tonight. Where do I start? Changes because of 1069, if I may, through the chair, Attorney Dupree Bruno and Superintendent Bernier, you mentioned some changes that staff is working on right now. I'd like to request that we as a board be fully briefed, because this is obviously an issue that is important to the public, and I'd like to be able to converse intelligently on the subject. So if we
So,
can do
Mr.
that.
Chair, I can address that immediately. We are planning both workshops and briefings regarding all things books and books related.
Great.
This team is fully prepared. We've been vetting the PowerPoints and getting prepared for those presentations. This was not a procedural event today. This was a policy event. In your one-on-ones, we've been sharing information and sharing what's been transpiring. We'll continue to do so, but we'll bring that information forward to the public as well, because the public input will be incredibly important.
Mr. Chairman.
Proceed.
And I will also be briefing the board during our one-on-one on some of the highlights from the legislative session, to include HB 1069. So I think next week is our next one-on-one, so that's on the list.
And I think I failed earlier to recognize you and Attorney Huffman in your presentation of the law surrounding this issue at Curriculum Advisory. It was outstanding. It was really, really good. Okay, next is graduation for Island Park, Coronado, and North Nicholas. Two of my colleagues were there. It was phenomenal. The speaker, the commencement speaker, was just so, I mean, he got up there in like jeans and a t-shirt, and I was like, oh no, what are we looking at here? But he was so incredibly inspiring, I think. And, you know, we all love graduations, so enough said there. I have attended my very last FHSAA board meeting. That is why I wasn't able to be physically present here. I served 6 years on that board, and I don't think I've ever said it in Lee County, but I used to say it in Gainesville all the time, that was my favorite part about being a school board member. Sorry, take no offense. But it was my favorite part about being a school board member, because there was no politics at the table at all. There was no politics coming from the public speakers. There was no politics coming, well, there's some politics sometimes came from our stakeholders, but we were able to resist it as a board until about 2 years ago, when the board membership changed a little bit and politics started to creep in. But before that period of time, what we had was we had superintendents, and we had heads of school for private schools, and we had athletic directors, and we had people who were experts in athletics in the state of Florida, who sat around and really grappled with issues that were going to impact student athletes and did their best to make decisions that were fair to all kids, taking into consideration student athletes' individual circumstances. That was what I loved about being on that board. There was no politics. Over the past couple of years, the politics has creeped in, and I fear that the changes being made at the FHSAA in terms of the board membership are going to mean that student athletes in Florida are now dictated by politics. That's my fear. My hope and my continued prayer will be that expertise rules the day, and that student athletes are always placed first. That being said, honest to God and true, the most fun I've had on a school board is serving on that board. I want to apologize to my colleagues about the communication from me in the car on the ride home. I did not join that meeting until 12:30. I believe it started at 12. So when you said, Mrs. Patrica, do you have any comments? I had just called into the meeting, so I didn't have any comments because I didn't know what you guys were talking about. That being said, I've gone back and watched the meeting, and I'd like to recommend, two things I want to say. Number one, I love working with this board. The level of this is what I would have said if I was sitting here that day. The level of professionalism has increased significantly since November, and I'm very, very grateful that we are focused on our work. We do our work and we leave. That being said, there was some discussion about what we can do to improve upon some of the lower points, and I'd like to recommend FSBA Master Board training. That was touted several times while we were up in up in Tampa last week as being incredibly successful and something that's wonderful. So if I may pause here and ask whether we can ask the board whether it's something that you're interested in pursuing, so we can give that direction to the superintendent or to the chair.
You can proceed to ask.
So is there interest? Yes, no, maybe?
Yes. I mean, I learn something every time I go there, so.
Great.
We have to work in our schedule. That's the hard part.
I'd be interested in hearing more. I want to get a better idea of what it is, but I'm open to it.
Okay, so who would pursue that? Go ahead.
I think it's part of one of our policies as well.
Okay.
I can't remember the number, but it's it's policy one something that we do master board training.
It's also in your protocol manual.
Yeah, so, I mean, it's there, so it's saying that that's what so we're asking that question, but we already have it in writing that that's what we do, just as a FYI.
Okay, so do we ask the superintendent to pursue that, or do we ask the chair to pursue that? I don't know. I'm asking.
With your permission?
Yes.
I'd be more than happy to pursue that as we look towards the annual evaluation of the board and working in the strategic plan format. I think we have an opportunity for it. Dr. Savage and I will work together to make some contacts, get more information to the board so that they can be better informed, and then in one-on-ones and then at another public meeting, we can have a discussion about formally adopting a schedule if that's the direction and pleasure of the board.
Great, thank you. Okay, moving on. The communication survey, do you know that a communication survey went out to your families, Dr. Bernier, through the chair?
I am.
Okay, so it was great, but ironically, I was on social media and I saw a meme that said, quote, "My last child graduates from high school tomorrow, and I am excited about never receiving another school email ever again." So that is that is what I said in my response to the thing. I just thought it was really funny. Okay, I went to Avid College and Career Week at Sunshine Elementary last week. I spoke to 3 different classrooms about my career and how I got to where I am. I really focused a lot on my time out of the workforce when I took the time out of the full-time workforce to raise my children, because to me that's the most important work that I've done in my career. Was raising my children. So I focused a lot on that with the kids, and I downplayed the rest of the stuff. Insurance task force, the number of enrollees is down. Now the number of overall enrollees is up. Why? Because of the family coverage, which has been very well received, but the number of initial enrollees, and I'm probably using the incorrect vocabulary, but the number of initial enrollees is down. Why? Because the number of employees we are bleeding. And that was, I know that we're having difficulty recruiting and retaining teachers and staff, but to see it on piece of paper in an insurance perspective just really drove the point home for me. So I wanted to bring that to the board's attention. I would like to recognize our chair for his recognition in Tampa last week. He received the Pineapple Report Award for Community Engagement. Is that correct?
Correct.
It was community engagement, family and community engagement. I wanted to recognize you for that. I thought that was awesome. I would have been there to celebrate if I wasn't at a required dinner. Last thing I want to talk about, I do have 2 things that I need to talk about tonight, but the last thing I'll talk about today is Mike Martin, retired from FGCU, and he has not been recognized at this table. And Mike Martin was such an amazingly strong supporter of our kids, our staff, and our our mission, our vision, everything we did, he supported. And I love that guy. And he's still here. He's working at the Collaboratory right now. But seeing him step away from FGCU made me a little bit sad. And I wanted to recognize him publicly at the table. Those are my comments for now. Thank you.
Ms. Juvenelli?
Thank you. Well, I'm trying to think how many times we've done master board training. Do we do it with the second? We did the first time. I know I've done it once, and I think yeah, so I'm game because I think it's good team building. So, but real quick, thank you, Ms. Morgan, for your update you sent us regarding FSBA. Apparently, we must have been on the off, because I don't think, you took the same class as I took, I guess, but there was different times. So I think you were we went opposite. But, so just thank you for that update. I appreciate it. And just real quick, regarding the book challenge, I do believe all books are important, and I think it has to be age appropriate, and I will support the law that is required of us on how they're presented to children. I also want to be real clear about my whole thing about the book challenging. The challenger has to read the book by the entirety. I don't know who's going to police that, and that was my concern, is like, someone's going to say they read it. Are we going to police it? They did or didn't? Are we going to give them a test? I mean, so I just think that we have to be careful about what our expectation is, because, I mean, the challenger could be a group of people. So are we going to make sure that all 10 of those people have read it? I mean, I think just we're taking that to the little bit of extreme. When someone challenges a book, they really have a good reason, I would think. And if not, then the process will pretty much determine that, won't it? So I'm very happy with the policy and all the work that curriculum and Dr. Spiro's staff worked on that. I was in that process, or got to watch it unfold to the community and got to hear the community. And so that's how I think the value of hearing those individuals and it being recorded was important, because other people got to hear it too that choose to go and listen to the books. And so I just appreciate the speakers that came and spoke regarding the books and the challenge process and their passion in that, because we have to value that, and I find value in that. So thank you. That's it.
Thank you. I'm reserving my comments until tonight. Do we have anything from Dr. Bernier?
The only thing, Mr. Chair, that I would add is we're currently experiencing an outage from the platform. We are working on it at the minute and hope to have it operational soon. We will continue to go to Diligent status page for updates, and we appreciate not only your patience but the public's patience as we attempt to resolve this matter. It is definitely a problem with the Diligent brand and board docs. It is not an internet connection process.
Thank you. Go ahead, Ms. Juvenelli.
I'm sorry, so what does that mean for this evening?
It means we're working on it and trying to get it fixed.
Okay, good luck.
This is a transitional and developmental process.
Yeah, may I make a suggestion?
Go
Could I
ahead.
suggest that we have a couple of paper copies of the agenda ready in the event we're not up and running in time for the public, please and thank you.
And Mr. Superintendent, can we confirm we can still search for dogs on Google?
I can before the meeting is out.
Okay, thank you. Attorney Dupree Bruno, do you have any report?
No, thank you.
Okay, thank you. We will have a parent university reception at 5 p.m. followed by our action meeting at 6 o'clock. Seeing no other business to come before this board, this meeting is adjourned at 4:19. Thank you, everyone.